My Lord, the Honorable Chief Justice of the Republic of Uganda, my Lord, the Honorable Deputy Chief Justice Emeritus, my Lord, the Honorable, the Principal Judge, my Lords, the Justices and the Judges of the Courts of Judicature, Your Worships, the Registrars and the Magistrates present, our distinguished guests, ladies and gentlemen, we warmly welcome you and a very good morning to all of you, my Lords. My Lords, we are going to start off the day with a prayer, and then we shall invite the chair of the session to take us through. I request Honorable Justice Chinobe to please take us through a prayer this morning. Thank you so much, my Lord.
Let's humble ourselves for a word of prayer. Almighty God, we give you all the glory and all the honor for today. We thank you for the gift of life. We thank you for the gift of calling. And Lord Father, as we deliberate today, we pray that you shall grace us with your wisdom. May these deliberations be fruitful. In the name of Jesus, I pray. Amen.
Amen. Thank you so much, my Lord. Without further ado, my Lord, the Honorable, the Chief Justice, please allow me to invite the chair of the session, Honorable Justice Anthony Wabwire, the Judge of the Industrial Court, to chair the next session. You're welcome, my Lord. Thank you so much.
The Honorable the Chief Justice, the Principal Judge, Your Lordships, Your Worships, ladies and gentlemen, the panel this morning will discuss the integration of artificial intelligence into effective and efficient case management. My Lords, Your Worships, please join me in welcoming to my immediate right the Honorable Justice Christopher Izama Madrama, JSC. Justices Frederick Egonda Ntende, Geoffrey Chiliabwire, and John Mike Mosisi, JJA, JJCC. Justice Richard Wejuli Wabwire, J, and their worships, I see His Worship Joel Wegoye. The final of our panelists, Mr. Robert Chirunda Esquire, will attend virtually, time permitting. Honorable Chief Justice, Principal Judge, the panel congratulates you upon your appointments to high office. My Lords, we were given a 40-minute window, and because of that, we asked AI how we should utilize it. I believe we have a PowerPoint of the unanimous answers. ChatGPT told us to keep it high level, no deep technical details. Gemini AI suggested we stick to one central argument. And GenSpark AI told us to cut out the details aggressively, stick to the core. My Lords, AI has set the ground rules. We will keep it short. In AI speak, let us now take a very deep dive. I would invite the Honorable Justice Christopher Madrama to present the main paper.
Thank you, my Lord, Honorable Chief Justice, my Lord, the Principal Judge. Let me adopt the protocol as late. As you notice, we are constrained by time, and I have summarized document which I'll read out. I hope it will come out clearly how we can integrate artificial intelligence and technology to help us to overcome burdens. Now, the narrative of the Ugandan judiciary has been one of resilience against what international observers have termed relentless and crushing workloads. We have normalized the culture of hard work, which is synonymous with physical exhaustion, where a backlog of over 160,000 cases battled with long nights, handwritten records, and the force of the human will. However, the 27th Judges Conference theme compels us to admit a difficult truth, which is that a stressed judge is an endangered asset. In other words, when you are stressed, you can't go far. So the cognitive load imposed for repetitive tasks, the physical strain of manual recording, anxiety of managing a docket of logistics are primary drivers of the burnout. So this suggests that the human brain has a finite amount of working space and memory, and handwritten notes, tracking baby funds, tracking research, and all these things require deep thinking, and legal analysis is diminished somehow because of this repetitive and stressful work. So today we look at a paradigm shift. We are not discussing integration of artificial intelligence merely to be modern. We are discussing it as a mechanism that it has nothing to do with artificial intelligence. It's some manual interference. So we are looking at artificial intelligence, dubbed AI, as a mechanism for offloading some of the cognitive offloading. Our objective is to transfer the burden of memory, scheduling, transcription, routine drafting from the human mind to the machine or the program. By doing so, we liberate the judicial officer's energy for the one task no machine can do, that is the wise, empathetic, and discretionary adjudication of disputes. Now, let us begin with the most tangible source of judicial fatigue, the manual recording of proceedings, the image of a judge who is hunched over on burning midnight oil, taking long hand of witness testimonies is an image that belongs to the 19th century. Let all of us understand that that is even before the British came here. It slows down trials, causes repetitive strain, injury, and delays production of the record of proceedings by weeks or months, stalling appeals and frustrating litigants. Now, I'm pleased to inform you that we have obtained TurboScribe, which is a one-day transcription engine that is artificial intelligence. Its capacities are that it can transcribe 99% accurately what you say in the proceedings. It can recognize different speakers. It can translate to local languages, let us say Luganda, Lusoga, Ateso, Luo, and Unyankole, among others, also Swahili. In other words, you can translate the transcript into any of those local languages, and more are being developed. Now it eliminates the transcription bottleneck that paralyzes appellate courts. And it allows the judge to capture demeanor instead of concentrating on what words to write, whether the spelling of the name is correct, etc. So the next one is breaking the language barrier. I've already explained it can translate. Then we have speech recognition for judgment writing. Speech recognition has been revolutionized. It no longer requires you to train for the engine to adapt to your accent and your words, because every person's words are like fingerprints. So each person is different. Now, it's no longer so. You can directly dictate to the computer with a microphone and it will write for you. And for this, there are so many speech to text programs, but I want to introduce to you the Windows 11 program, which is the Voice Access. Voice Access is available in your Windows 11 and you can use it within 1 or 2 hours. You'll be able to proficiently write something with voice and do minimal editing. Now, we can also look at deepening ECMIS. ECMIS from being a repository to just a filing cabinet to an intelligent agent, which can do a lot of the tasks that we do. Now, having rolled out ECMIS in the current state, it is just a filing cabinet. We must now upgrade it with the artificial intelligence. What can artificial intelligence do? There is intelligent document processing. I'm sure Wegoya will tell us more about it. When it is integrated, it uses the natural language processing to read uploaded documents. Its function is that it analyzes the content, verifies things in the document, and it can flag it immediately for administrative work in this way or that way. I don't need to give you the details, but it can classify it as a commercial dispute, this kind of dispute, etc. And it can help with allocation of files. Then artificial intelligence can help you with summarization and research, but in relation to ECMIS, how many minutes now? 1 minute. Whoa. We can, it can summarize the contents, long proceedings. It can help you with research. It can help you with flagging of cases. If the defense is due, judgment is due. It can help you with managing court administration, court fees, and revenue collection, bail deposits when bail is due after judgment is delivered, due for refund, and things like that. It can help you with predictive analysis for resource allocation, which circuits, for instance, will have more load. It can help you to do in-depth research. It can help with giving advice to indigent persons in a chatbot which can be created to tell somebody from your pleadings, this is likely to be your chances of success. Assisting with ADR. Because I have such a short time left, I'm about to conclude. It can help with allocation of cases, especially giving it a more scientific caseload mechanism, where you find one case with so many issues will be more weighty than somebody doing plea bargaining rather than weighing the number of cases. Now, in conclusion, my lords, ladies and gentlemen, by utilizing transcription, speech recognition, using AI tools to help you with the research and with management, you are offloading a lot of the repetitive tasks that are bedeviling judges and making them burn out. And this data-driven administrative tasks are much more efficient, creating more efficiency, and we become what we have been aspiring to do, doing justice speedily and in the more efficiently and more in-depth, because you have more incisive tools for research, etc. Artificial intelligence is here as a tool to aid us in our work. Thank you.
Thank you very much, Justice Madrama. The 7-page paper that Justice Madrama has just delivered was subjected to the Industrial Court's in-house built IA with an instruction to give a summary not exceeding 100 words. We will beam an 89-word summary. So AI is here, it's working. My Lord, Justice Egonda Ntende, you have had a history with technology in the judiciary, and particularly the journey into digitization of the judiciary, dating back as far back as 1997 with the introduction of CAS. My Lord, with the advent of AI, do you see space for the practical application of AI tools within our existing systems, ULI and ECMIS? My Lord, you have just over 3 minutes.
Thank you, my Lord Chair. The important thing to start with when we talk of our databases, CAS, ECMIS, what are the necessary prerequisites for these programs to be useful? CAS has been with us for 31 years. We haven't achieved 100% penetration. I'm not sure if it is at 40 or 60%. ECMIS is not quite the same story, but precedent is a powerful thing. It could follow the same story. So before we can tap into the fruits of AI, we need to ensure that these programs are fully embraced, data is entered, they are fully used. And there lies in the problem for the judiciary of Uganda. There are just too many initiatives that have been initiated. Consummation has been rather low. So AI has potential. We are its last stages. Thank you.
Thank you very much, my lord. And I think that ties in nicely now that if we are classified as the worst enemy of AI, I must ask my Lord Justice Chiriagwide, who has been deeply, very deeply embedded in developing a judgment writing tool. My Lord, at the 24th Annual Judges Conference, you presented a paper where you discussed predictive analytics and predictive justice. Justice Madrama suggests that a judge should be liberated to make decisions with wisdom, empathy, and integrity. My Lord, could we have your thoughts on permitting the judge to decide, permitting a judge to focus on a judgment and not to spend their time on tedious tasks of assembling the architecture of the judgment? My Lord, you have 3 minutes.
Thank you, Chair, and all protocol observed. AI is all about managing and applying data in a manner that is faster than ever before. So if the court record can be viewed as a compilation of data involving pleadings, submissions, laws, and authorities supporting the cases, then AI can be used to manage that data in the court record for the benefit of the presiding officer. So AI can be used, for example, to summarize the arguments on record, the legal authorities that have been placed there as well, to search out the laws and various authorities, use data research engines like we have Yuli and LexisNexis. These are low-risk tasks that AI can do for judicial officers and really help them improve their judicial wellness. So I think that is where we are right now. We can use AI to help us manage the data that is coming to us and then free the judicial officer to make the decision. Whether that will be the way into the next future is yet to be seen. Thank you.
Thank you very much, my Lord. Justice John Mike Musisi. We now have quite some sufficient video conferencing facilities. And some of these facilities reduce the physical travel burdens of litigants. They reduce the physical travel burdens of prisoner transport, and therefore are convenient. If we build an AI system that requires smartphone access, with a smartphone per capita in this room of 2 gadgets, Do we think that that would assist the peasants in the rural village? My lord, if we could have your thoughts in 2 minutes.
Thank you very much. There's no doubt that the introduction of video conferencing has reduced physical travel for judges, minimized security risks in prisoner transport. It has cut delays in costs, and there is increased administrative efficiency. However, these real gains must be acknowledged, of course, but we must know that efficiency is not the same as justice. If access to courts increasingly depends on owning a smartphone, affording internet data, understanding digital forms, then we risk building a justice system that quietly excludes the very people it exists to protect. The peasant in the village often has no smartphone, cannot afford data, may be illiterate, and may live far from electricity or network coverage. What can we do in those circumstances? Because if we don't, we risk having urban justice versus rural justice, wealthy justice versus poor justice, and the fast justice versus inaccessible justice. What we need to do in those circumstances is we need to provide physical help desks in courts, public access points in local council offices, assistance through court clerks and registries, interfaces in local languages, and including audio support, policies that protect litigants who choose traditional, non-digital procedures. That way, we protect the poor litigant, and the judges themselves retain the authorship of their decisions, and responsibility for liberty remains human and visible. Thank you very much.
Thank you very much, Justice Moses. Justice with Julie, just picking up from Justice Moses' answer on the matter of access to justice. Your Lordship sits at the International Crimes Division, and Your Lordship deals with very complex cases. They are particularly big data cases. You have voluminous amounts. We could actually call them oceanic amounts of evidence. The Chief Justice, in his remarks on Monday, spoke about judicial trauma. In managing your large volumes of evidence, in, for instance, the Koroyo case or the Kampala bombing cases, where you have evidence that reaches terabytes, huge evidence, do you see judicial wellness in employing AI tools to analyze data and to mitigate judicial trauma? My Lord, we will give you 3 minutes.
Yeah, thank you, my Lord. Procedure. You see, it's not only Koyelo and Kampala bombing cases, but we say all high volume cases, typically cases at the ICD, will arise from a prolonged conflict or several participants or suspects in these cases. So there's a lot of forensic evidence collected, documentary evidence, testimonies. So the
In Coelho, yes, of course, Coelho and Apanabon find the volume, sheer volume of documentary evidence almost bury the judges, in paperwork. So to answer the question, and like my colleagues already mentioned, AI will go a long way in mitigating some of the pressure on the judges handling such evidence, documentary evidence, forensic evidence, by way of summarization of witness testimonies, reduction of statements, indexing, and in that way really free up time for judges to more easily review, summarize testimonies, reflect on the proceedings, on the record proceedings, and in short way, of course, that comes with the credit to well-being, but also the benefit of then being able to render higher quality education. So yes, to answer the question, the relief that comes from the use of AI undoubtedly renders the benefit of the well-being to judicial officers involved in such trial of high volume cases.
Thank you very much, my lord. You raised the important point on wellness and being able to free up the judge's time. That takes me to your worship, Wegoye. You had Yuli's law reporting function. Again, in his remarks on Monday, the Honorable Chief Justice heralded Yuli and LexisNexis as more than case reporting tools. In fact, in our conversation earlier, you suggested that the uptake of LexisNexis is very low for the judges. You put the percentages as somewhere 4% usage on Yuli. First, and I think this is very, very important, can you bring us up to speed with the notable capabilities of the tools Yuli and LexisNexis beyond just the law reports? That in terms of the benefit to the judges.
My Lord Chair, I'll speak to both Yuli and LexisNexis in three aspects. One is AI-assisted research, data analytics, and performance management. In terms of what we have been talking about in AI-assisted research, both Yuli and through this we have to thank the judiciary management. Both Yuli and LexisNexis have been upgraded, and AI has been fully incorporated in both Yuli and LexisNexis. In terms of capabilities, I'll start with LexisNexis. It has functions like speech to text. It can help you draft the documents. It can have a conversation with you in terms of what you may be looking for. That means even when you're fatigued, you can just have a conversation with it and it will be able to give you the information you want. You can also upload the documents and can help you analyze and give you an opinion concerning. I'll give an example. If you have a record of appeal like the Court of Appeal, you can upload the proceedings, the submissions, and then it will be able to give you an opinion on what the case, the decision can be in that specific case. Now, those functions are also applicable to Yuli. It also is fully integrated with AI and can assist you. Now, for Yuli, I'll just start with one example. You don't have to be on Yuli for it to do research for you. We have what we call AI agents. You can search in a search request and go and sleep. In the morning, all the results will be found on your email address. Now, that is among other functions. But I'll also inform you that the Judicial Training Institute offers free training at the convenience of both the trainer and the trainee on both Yuli and LexisNexis. But more importantly, on data analytics, I'll give an example. Yesterday, there was a conversation on sentencing. I'm going to use it as an example to show the capabilities of these systems. Sentencing trends, there is inconsistency both in the individual judicial officers, but also there is inconsistency in the courts. Those are two different aspects. But Yuli can accurately tell you that a specific judge is inconsistent in say sentencing murder, whereby the inconsistencies in say giving a higher sentences in murder to different offenders. But it can also tell you that there are inconsistencies among different judicial officers. So those are two different aspects. Now Yuli can actually accurately predict such kind of information based on the data we incorporate. And it is authentic because currently we upload about 4,000 documents. That means we have enough data to analyze and give you an accurate result. But also in terms of performance management, Yuli can tell you, say you've handled 100 cases and 80 have gone on appeal. It can actually tell you that 60 have been overturned, 20 have been upheld. Now, this is down to qualitative analysis of data, but it can also do things like gender-based violence cases and make for you an analysis as far as where the issues, as far as the court, and can recommend even a training as far as gender-based violence is concerned. So that's how powerful these systems are concerned. But also we have to be aware that there is a lot more to learn in these systems. But we should also take the opportunity that the Judicial Training Institute offers training. And currently we have about 3 universities, and to show you how important it is. Research, the component of research methods under the Bachelor's of Laws, they are incorporating a training on Yuli almost every semester we have discussions with Makerere University, IU, and currently we are also going to discuss with Kampala International University, because they have seen that a lawyer is not about just training them about what commercial law is. You have to have the skill to utilize these resources, but also it has gone beyond just a legal repository. You have to be aware that AI assisted research is in these systems. Thank you very much.
Thank you very much. Your Worship Wagoye, you were telling us that the lawyer of the future, the one training at university with skills in utilizing Yuli, is going to appear before their lordships. And that speaks to the judicial officers' preparedness. Justice Chidiabwile, during some of our maiden appearances before you as a young baby judge, if I am not wrong, that's what they called you. The computers at that time were relegated to a corner of the judges' chambers. They were actually covered with plastic to protect them from dust damage. Now, we simply cannot work without the computers. Indeed, we are having a paperless conference. So those are the advantages in technology and AI. But is AI then threatening the role of judges or augmenting the work that we do?
So you asked the question, is AI a threat the role of judicial officers or judges? Sincerely, with the speed of technological advancement, I don't know, especially in the long run. But for now, the understanding is that judicial officers must determine the case and not technology. So the human loop in the use of technology is sacrosanct. It must be applied. So technology must augment the work that judicial officers do, and it is very important that judicial officers adopt technological developments, if anything else, to improve judicial wellness. We have had some challenges in change management with regard to the use of CAS, use of ICMIS, and one wonders why, since the technology is there to augment the judicial officer's work. That said, Let me tell you a little bit about China. China has AI-equipped smart courts with robot judges in Hangzhou and Beijing. They also have a court in Shanghai called Court 206. These ones actually are moving towards decision making. Estonia has, like we do have, a small claims court, which uses AI to determine disputes which are below the value of 7,000 euros. So you can see where we are, where we hope to go, and where we may end. So right now we're talking about argumentation, but we may slide over time to utilization. Thank you.
Thank you very much. And on utilization, I think Justice Wabwile, it would be important for us to understand from your viewpoint whether you see any pitfalls in utilization.
When integrating AI, integrating AI into the system, just promises efficient like case analysis. It carries risks such as undermining fairness, transparency, trust, and it has pitfalls that were picked up or generated by pitfalls that are actually generated by AI, which I'll share with you. Bias and discrimination. AI trained on biased historical data algorithms can perpetuate inequalities, for example, in sentences, and disproportionately affect certain groups. Because if you feed it with garbage, it will bring out garbage. If you feed it and don't update, it might just perpetuate the same, it says, it thinks what it knows. So bias is one of the highest pitfalls that, and discrimination, child matters, is one of those pitfalls that AI says, yes, I'm good, but be mindful of, I could easily do this. I don't have capacity to think in certain ways. Lack of transparencies, black box. See, AI obscures decision making, hindering challenges recommendations because it has proprietary issues. So AI will generate an output. You ask and you say, look, I'll give you this, but we don't know how it has arrived at that decision. No rational standard. So AI will put it there, and but no rational standard. So it also has hallucinations. You've heard about cases where that are imaginary, that don't exist. So AI will cite a very imaginary case, and we've heard of lawyers who have gone and told cited cases that don't exist, but also deep fakes. In this season, pre-election season or election season, campaign seasons, we saw clips of very senior figures in dance strokes on social media. It can clone voices, so certain statements can be attributed to you. So this can interfere with evidence. You can produce His Lordship, the CJ, with a gun in hand and shooting somebody from AI, and that can be brought in court as evidence. Or the gun can be removed from somebody's hands that are actually shot and say this is what was recorded on CCTV. So deepfakes, pitfalls. We should be careful with how we use AI and have capacity to conduct audits and ensure that AI is appropriately structured to give us what we want. Privacy, security data handling invites breaches or cyber attacks. So you could write your judgment, and tomorrow it is a completely different thing. Conviction, acquittal, because AI has infiltrated your, Then accountability challenges. Yeah. So who is ultimately responsible for what comes out of an AI-generated opinion? You know, is it the inquirer? Is it the litigator? Is it the judge in court? So those questions, those are pitfalls that you know. So as we open the door to AI, you must be brave enough to ask a few questions. I'll run through this very quickly.
Justice Wawide, you make some very important points on deepfakes and evidence, particularly in the election season to start with, but the aspects, criminal cases, even commercial matters. These are important points, and not to interrupt you, but it would be interesting that we have had perspectives from the bench. It would be very interesting to understand what council think on some of these points. We had invited Mr. Chirunda, but he is not able to be physically present. It is the age of AI. I want to find out whether AI can tell us his viewpoints on deepfakes in elections, the question on copyright for the judgment, who owns it? Is it AI or the judge? And whether there is a correlation between judicial wellness and council wellness, if AI can be of some assistance on those answers. And I hope that is not a deep fake.
Distinguished ladies and gentlemen, thank you for the privilege of joining you today. I regret not being able to attend in person, and I most sincerely hope you will find my thoughts useful as you deliberate. I will comment very briefly on 3 questions that Justice Wawide posed to me. On question 1, deepfakes and the evidentiary balance. Deepfakes are serious but not unfamiliar. Uganda's existing law in statute and a growing body of precedent already contains the tools and the framework to deal with these deepfakes. A 3-stage approach in this context is helpful. Stage 1, the challenger of the evidence must raise genuine doubt. They may rely on contextual inconsistencies, metadata concerns, or even expert opinion. However, mere denial is not enough. Stage number 2, once doubt is raised, the proponent must demonstrate how the recording was created, preserved, and account for chain of custody, as well as provide corroboration from sources not susceptible to AI manipulation. At stage 3, the court would then exercise its inherent discretion to assess whether probative value in this case outweighs the risk of sophisticated fakery receiving undue weight. This approach, my lords, preserves both interests. On the one hand, legitimate recordings remain admissible, while on the other, manufactured evidence does not become the sole basis for conviction, electoral nullification, or reputation destruction, or similar consequential adjudication. Ultimately, my lords, AI may blur reality, but judicial reasoning always restores clarity. On question 2, AI, copyright, and practice directions. 3 quick points, my lords. First, Ugandan copyright law requires that the holder of a copyright is a human. A judgment is an exercise of judicial authority. While AI may assist in research or drafting, authorship remains with the judge because reasoning, discretion, and responsibility remain decidedly human. AI is an instrument, much like a law clerk or a legal database, and therefore it cannot own judgment. Number 2, on council's use and disclosure. The risk is not AI use, but uncritical reliance. Routine assistive use does not require disclosure. However, where AI generates substantive legal analysis or authorities, counsel remain absolutely responsible for accuracy. I would argue that that responsibility actually fits very well within the existing framework of the Advocates' Professional Conduct Regulations. Indeed, elsewhere, the courts have sanctioned lawyers who cited fabricated cases generated by ChatGPT and similar tools. On the third point of practice directions, my lord, it is indeed true that light touch guidance would be most valuable. I would recommend building that guidance on 3 principles. First, AI is a permissible assistive tool, not a decision maker. Secondly, Judges and counsel remain fully responsible for all outputs. And thirdly, fabricated authorities attract sanctions and the courts retain the discretion to require verification. Indeed, courts elsewhere, such as in England and Wales and in Singapore, have issued guidance along similar lines. My lords, in short, AI may assist the work of justice, but it cannot own it, replace it, or excuse responsibility. On the last question, my lords, counsel wellness through the use of AI. The current pain points for advocates are clear: tracking hearing dates across multiple courts, document service, case status monitoring, and registry coordination. These tasks consume hours and yet require no legal skill. Since ICMIS and Yuli can already interface and integrate with law firms through secure APIs, the wellness benefits of integrating with AI would be immediate. I would propose three. First, AI would help with automatic calendar synchronization, which would eliminate missed dates. Second, real-time status updates would be easier to achieve, and this would reduce physical trips to the courts and to the registries. And third, digital document exchange would actually help in cutting mechanical filing time. My lords, many adjournments arise not from bad faith, but from administrative chaos and miscoordination. API integration that is AI-enabled would help advance knowledge of conflicts in scheduling, timely document exchange, and protect time for preparation for cases. Judicial wellness as well as counsel wellness would increase through reduced disruption. However, the challenges I highlighted with questions 1 and 2 would remain, although in a slightly different fashion. AI can handle administrative drudgery. It cannot exercise professional judgment or even assist in determining courtroom dynamics so as to inform counsel on how to adjust the strategy accordingly. Ultimately, my lords, counsel wellness, like judicial wellness, begins with removing the obstacles to doing the work that we're trained to do. I thank you very much for listening to me, and I wish you wonderful deliberations for the rest of the day.
We can confirm that was not a deep fake because we did hold an interview. Mr. Chirunda spoke about an API, which quite simply is an application programming interface. The counsel's computer can speak to ECIMIS. And what has emerged quite a bit is that there are real worries around fake citations that do not exist. While speaking at a judiciary event on digital transformation, a justice of the Supreme Court, and I will get to that shortly, said this: "Yesterday, I was reading a case where a judge was horrified because of what had happened to him. Lawyers filed submissions using AI. All the authorities were fake. The language was beautiful, but when the judge cross-referenced the authorities, all of them were created by artificial intelligence." That was attributed to Justice Isaac Lenaola on the 16th of May 2025, reported by Capital News. Perhaps this would be an opportunity to establish whether he actually said that, because he is in the room. My Lord Chief Justice, Principal Judge, permit me to invite Justice Isaac Lenaola, Justice of the Supreme Court of Kenya, and who has the kind of CV that you would best be advised to log on to read. My Lord, the perspectives from Kenya. You have 15 minutes.
Thank you very much. For that, 20. My Lord CJ, PJ, congratulations on your appointment. And thank you very much for inviting me again to speak to my colleague judges on this very important subject. Last year, I spoke to the Court of Appeal and the Supreme Court. I'm happy that my brothers and sisters of the High Court will now give the opportunity to confirm that I'm not AI generated. From Kenya, over the last couple of years, we have gone deep into the use of technology in our processes. And we are basically now using e-filing, virtual courts, e-stamping, e-service, and we are well on our way to adopting AI. The use of AI is new in most African jurisdictions. But listening to my colleagues from Uganda, it is obvious that you have sufficient information and knowledge to adopt it and use it in coming days with the cautions that we have had. I chair the ICMS Committee of the Judiciary, which is leading in the adoption of technology in our judiciary. But in the use of AI, which we have started doing, we have one basic principle, and that our use of AI should be strategic, should be ethical, should be responsible and controlled, so that it is not a decisional tool, but a supportive, non-decisional tool within our processes. It is not intended to replace judicial reasoning, discretion, or independence, but to augment judicial efficiency in the organization, structuring, summarization, and retrieval of information, particularly in complex matters characterized by voluminous records, multiple parties, and interrelated legal and factual issues, which my brother Richard Bujuli spoke about. What is the problem we in the judiciary of Kenya are trying to address? We are trying to address the high caseload and backlogs that we are suffering from. But listening to the statistics from Uganda, I think we are a little better off. The Supreme Court of Kenya is sitting on 46 undetermined applications and petitions. The Supreme Court of Uganda has 1,000. The Court of Appeal of Uganda has 13,000 pending cases. The Court of Appeal of Kenya has 13,000 pending cases. Our High Court and Labor Court and Land Court have enormous backlogs. Number two, we are trying to see how to avoid frequent adjournments due to late filings and requests for adjournments by advocates. We also have a problem where transfers and reassignments create backlog in the stations that a judge is coming from and create backlogs in the station a judge is going to. And we are trying to use technology to ensure that this does not happen. We are also trying to ensure that complex and voluminous matters are addressed quickly and without delay. And from limited research, clerical and ICT support because of connectivity, power challenges, and technology. We also have the problem, which you suffer from, of time management constraints between hearings, writing duties, administrative rules, conferences like now, priority challenges. Some judges are not able to determine that all matters must go out before new matters get heard. So suddenly you start with a new one, then you keep forgetting the old ones, and you create back. How does technology help us not to have that problem? Of course, we have health and well-being considerations, fatigue, stress, judicial wellness or unwellness. How do we handle these matters? Where are we at today in the Kenya judiciary? We have developed artificial intelligence principles and guidelines to ensure ongoing, ethical, transparent, and accountable use of AI within the judiciary. Last year, we were caught in a very untidy situation where the Court of Appeal had a matter, a lawyer went to ChatGPT. The matter was about trademarks, and the ChatGPT gave him a statute which he used in his submissions, a non-Kenyan statute. This doesn't exist in our books. The judges in their judgment quickly picked that statute, referred to it in their judgment. What saved them was that they didn't determine the matter on the basis of their statute, but on the Trademarks Act. But it was embarrassing. And since I'm there now, it is true that we have found that lawyers in Kenya are using ChatGPT They're using Gemini and others, and not Cloud, which is more useful for lawyers. And we have now instances where lawyers have created fake authorities. But let me give you a story to make this more credible. A lawyer is given 7 days to file submissions in a case. He gives the file to his associate, to his intern, who quickly goes to artificial intelligence, creates this fantastic set of submissions, gives to the boss the same day. The boss reads, he's so impressed. He files at 5 p.m. on the online filing system. And then tomorrow, the following day at 8, he receives a call from his adversary and says, my brother, never have I seen such good submissions by my rival which support my case. Because the submissions were for the respondent, not for the applicant who they were appearing for. So this is a reality we are facing today. And so we are giving guidelines as a judiciary for ourselves, and I'm also working with the law society, so they give guidelines from their side. We also have a comprehensive draft of the artificial intelligence policy to provide an overarching governance framework. Kenya is one of the few countries where there is an AI policy. I think it's only South Africa and I think Ghana, Kenya, and others which have a policy. We are developing a policy following the government policy, and we should have the hours launched in the month of April together with the guidelines. We are developing, like my brother from Yuli has said, we are developing a case law database using an AI tool called Hakimu.ai. Hakimu.ai is going beyond what Kenya law is doing. It is faster in terms of retrieval of information. It takes you to the specific paragraph, the specific line, which is authority you require. Is that instead of giving you the whole judgment for you to pick out what it is, it takes you straight there. We are developing it in a way that, and we are launching it this year. We are developing in a way that later we can also do the translation and interpretation from one language to another. We are working with a technology called Whisper technology. Whisper technology is trained to have 680,000 hours of multilingual multitask near human interpretation, and it can identify 99 languages. So that as we go forward, even those who cannot read English will get these judgments in their languages. We are also working using MOUs with partners who can help us in the journey. And on Saturday this week, I will lead a delegation of the National Council Justice ICT Committee to Estonia, where we shall spend the whole week looking at some of the things that my brother and friend Geoffrey Kirobire is saying. We were told that they are the highest, they are the best destination in terms of e-justice. And so we want to see what they're doing and see what we can learn from them. The justification for what we intend to do as Kenya is because we need to organize and index voluminous case records. I think in the appellate courts, you now notice that evidence is coming more and more in the voluminous records. Judge Wanjala spoke about our presidential election petition, where we received evidence in canters, although I don't want to repeat the offending words, but you know what we said about that evidence. We also want to use it to summarize pleadings, submissions, and evidence. It is getting more difficult to summarize if we don't have these tools. The tools we are developing will help us to do that. Mapping out issues, parties, facts, and applicable law. Retrieve precedent and statutory provisions. I'll speak about hallucinations in a minute. Tracking pending judgments and aging matters. A lot of matters in our system fall off the cracks, and we have no system of retrieving them unless we develop such systems. We, of course, must reduce time spent on administrative and clerical tasks. I think someone spoke about it across the table. And then improve organization of complex case materials and enhance research efficiency. We have, each of us has 2 law clerks, legal researchers, and these tools will assist them in doing this. Yesterday, we spoke about the presidential election petition and preparedness. You don't have to wait for the matter to end for you to start writing. These tools can summarize the pleadings as they come. So writing the judgment will be easier because you spend more time on analysis and determination and the conclusion than summarizing the case for the parties. That should have been done long before you come to the evidence. Another lesson that we have learned in Kenya is that we as judges, even as we use some of these tools we are developing, we must independently verify, preferably through authoritative and human validated sources, what we incorporate into our decisions. You're aware of Judge Rodriguez from Brazil, who wrote a judgment. He took it to his assistant. The assistant drafted it. He gave it to the good judge. The good judge loved it like the good lawyer in Nakuru. And then he proceeded to deliver the judgment. And you know that today there are tools which can identify what you have used, whether you have used AI to write your whatever you have written. The lawyers went to AI and 90% of the judgment was AI generated. The judge is now being taken through disciplinary proceedings. Another, do you know about the lawyers in the US? There's a lawyer called Cohen who was involved in the Trump cases. He too, his law firm, the law firm representing him, used AI to write submissions. The judge discovered that some of them had hallucinations. They were fined $500,000 for what they had done because that amounts to contempt of court, according to that judge. So we as judges should never be found wanting. Imagine if the Supreme Court of Uganda or the Supreme Court of Kenya is caught using AI to develop a contested presidential election decision. What will the world say about that court? And I speak about my court with my hands raised because we are heading there next year. And therefore, we must not forget that the evidentiary test under the Evidence Act is applicable even if you're using AI-generated material. And the burden of proof is on the person who says that they didn't use AI to assert this contention. I was also asked to speak about the AI in decision-making and due process. My thinking is very simple. When public bodies or private bodies use AI, they ought to disclose in today's world that they used AI to develop some of the material. And therefore, the argument about human in the loop, is there a human being who has verified this? How much of it is AI is a conversation we must start having. This morning, if you watch BBC, there was an interesting piece. It says, panic on Wall Street due to AI disruptions. And the stock exchange in the US fell down last night because of fear that AI disrupted some of the tools in which the people invest. We must, as Africa, because we are slightly behind, learn from those examples and ensure that organizations such as the Revenue Authority and others that use AI do not abuse those tools. My brother, I think Kirabure, spoke about human in the loop. Whatever we do, let there be verification by a human being. Let me then turn to deepfakes, misinformation, and disinformation. Now, deepfakes are synthetic media, including fake audio, video, or images generated using AI technology and shared online. It portrays non-existent realities or events that have never occurred, often creating hyper-realistic digital forgeries that can seamlessly insert individuals into videos and images, making it appear as if a real person did or said something they never did. I'm sure you know that you see this on your social media pages every day. And I spoke about the one about the Chief Justice. In fact, when I looked at it again last night after the fantastic dinner, which went on until the same day we slept, the face of the Chief Justice was superimposed on the face of the Deputy Chief Justice and the third lady judge in our court. So this face of the CJ had three lady judges of our court in one image. So you are looking at it and you're wondering, is it your eyes cheating you? Are you seeing Jan Joki? Are you seeing the CJ? Are you just seeing the DCJ? But to a person out there who does not sit with them like we sit in court, this is Martha Koome saying the deputy chief justice, the deputy vice president ought to be returned to work. And they believe it, including my wife, who sent me the image yesterday. Misinformation is misleading or incorrect information that is shared without intention to deceive. It is incorrect news on social media, believing and forwarding unverified rumors, and outdated or wrong matter. So you get a fake news, you forward it to her, she forwards it to them, then all the judges have it, and they believe the Chief Justice is being treated in London because you have not seen him for 1 week. And that becomes the news. What is the effect for us judges? The most important qualifications in treating such evidence is the following. Is there imminent and irreparable harm done by this deepfake, misinformation, and disinformation? Treat the matter on a balance of convenience, the harm of continuing and allowing circulation vis-a-vis the freedom of expression. We in the Supreme Court of Kenya, every time we have a presidential election petition, we suffer this. And our reputations are harmed beyond repair. In 2022, I had 9 social media pages on X opened in my name and had 8 on Facebook opened in my name. And what they would do, they would pick one of my pictures from the internet, place it there, and then they put false information attributed to me, and then they start attacking me based on the false information they themselves had projected. So I've had to go to court in some instances to stop this reputational risk. I've had to go to Meta for Meta to pull down some of these, close some of the pages, pull down some of the information. But one has refused to come out of the Facebook. And it is Isaac Lenaola, judge of the Supreme Court. But the picture is of a socialite buxom from Kenya who I've never known or met. And every time I open my own page on social media, that one pops up. And Meta could not remove it, I don't know why. And I don't know who opened it. Thank God that only has 3 followers. So I think I'm safe to that extent. So we have the public interest considerations. You have seen a number of caricatures of our presidents. Just last month, a man called Harrison Nyende Mumia. Harrison Nyende Mumia is the president of the Kenya Atheists Association. These people don't believe that he's God. And what did he do? On his Facebook page, he digitally generated images portraying our president, William Ruto, as critically ill or deceased. And so he was charged with an offense under Section 22(1) of the Computer Misuse and Cybercrimes Act 2018. A lot of these things are coming, and I recall during the election petition of 2022, somebody brought a video of the Chief Justice allegedly involved in an accident and had died. The result was that the Chief Justice is in court with us. We don't have access to our phones, and our family is going crazy, thinking the Chief Justice is dead and she's in hospital or her body is in hospital. So we must, as judges, when people bring some of these applications to court, to seek that they stop the publication or they delete, how do we balance the public interest, reputational risk, and yet there's a right to publicize this information? And we have suffered as judges and the dispute leaders when these matters are taken to court. Just last week, a similar case went to court where somebody tried to stop the circulation of false information, and the judge said the right to freedom of expression supersedes any risk of damage to the applicant. I leave it to you whether that is a good decision or not. Judicial ethics in AI decision making. If
Justice Lenora,
I have exactly 3 minutes to go,
by your watch.
which is in Kenya time.
by the chair's watch,
Yes.
we would like to hear you on that point,
Thank you.
being the final point.
Thank you.
Thank you very much,
Thank you very much.
Judge.
The point about ethics is important. If you write a judgment and 85% of it is developed using AI and 15% of it is yours, whose judgment is it? AI. And who is AI? Did the AI take an oath of office to be impartial and fair? So I think we must be clear that whatever we do, we must know that AI is opaque sometimes. AI has hallucinations, and therefore we need to ensure that we are trained in knowing what is opaque about AI, knowing what AI can do wrong, but we retain the authority of the judgment. Mr. Chairman, allow me to just to speak on one last point in 1 minute. Predictive analytics. Lawyers in Kenya now have developed AI tools that predict what kind of judgment you may render based on your prior decisions, so that they use it to advise their clients. Justice Lenaola on matters like this generally rules like this, and therefore he will rule like this. And so let's avoid Lenaola. Let us go to Wanjala, who generally rules in our favor like this because he has done that before. Number two, be careful about cybersecurity in the use of these artificial tools. We have suffered in the judiciary of Kenya something called distributed denial of service attacks, DDoS, twice in very serious cases. Be careful about the sort of security you have. And lastly, I want to thank you very much for inviting me. And I hope that this conversation, because they are continuing, will also involve you coming to speak to us and we coming to speak to you, so we can share experiences and become better judges in this strange age of artificial intelligence. I thank you very much.
Mheshimiwa Jaji, it is only appropriate now to say tunakushukuru sana. Just before we go into the plenary, if we might have slide number 3. Slide number 3. Could AI give us slide number 3, please? Or do we have a deep fake AI? Number 3, please. That is number 4. That is number 5. And you can see we are talking about the human in the loop. We know these slides. Slide number 3 is a summary that we spoke about. ALFI there stands for Artificial Life Form Intelligent Entity, developed by our IT staff at the Industrial Court. What does that speak to? It speaks to some of the issues that Justice Lenaola raises. Ours is a closed loop. Our AI is inside the Industrial Court. So we are not interacting with outside sources. That, we are advised, is a security feature. The other two things, Justice Lenaola, in terms of index, we spent some time in South Africa. They have developed something called case lines, into which all the evidence is fed. So the judges are referred to specific lines within the system of evidence, the judges on their screens during the trial. So it is not which page, it is which case line. And the system generates the bundles for both sides. The point being that AI is very helpful in doing those tedious tasks of creating bundles and paginating as the parties fire. Just one final observation. The research capabilities and predictor models within ALFI now allow us to generate authorities based on the pleadings. What direction are each of these cases likely to take? My Lord Chief Justice, with your permission now, I should like to open the session up to the plenary. We will try to do this in 13 minutes so as to keep within the time allotted to us by show of hands. Yes, Your Worship. Atanga.
Thank you so much. I'll stand on the protocol that has already been established. I'm Juliet Hatanga, Registrar at the International Crimes Division. I'll start by posing a few questions. That is, how can we salvage the use of technology in evidence preservation? And what tools can the judiciary employ, and to what extent? Where am I coming from? At the International Crimes Division, we do handle quite complex cases. And just about last year, we got a mutual legal request from ICC. This request was for very technical evidence that we had in the old format, that is the VSH, and we had to convert it into a more contemporary version that would be appreciated. Now, the thing is, we had only one particular recording, which carries evidence not just only for the case that they needed, but it also had evidence of other incidents that happened during the insurgency in northern Uganda. Now, our ethical dilemma was, what do we do? When I contacted the IT department, they said, okay, let's send it to Makerere. Now, for me, as someone who is security conscious, it raises an issue of national security, because some of that evidence, it's the only evidence in the entire world, and it's only the ICD that has it. Now, how can we trust that the technology at the University Makerere department will preserve its integrity, its legitimacy? And so the big question then becomes, how can we salvage technology to ensure that evidence is still preserved within the context of judicial wellness, and we don't have to look through this long VHS format and not lose also the context? Thank you very much.
My Lord Chief Justice.
Thank you so much, the panel, and thank you so much, Justice Renora, for that wonderful presentation. Let me begin with maybe the question Hatanga raised, and I relate it with the industrial court. When I visited the industrial court, I found they had their own internal IT developers. So they have developed their own IKIMIS. They have done all of those things. I think you've seen what Justice Wabwira has shown you there. And I think part of my plan is to have our own internal developers. I was supposed to have a meeting with the IT team. Because of the risks associated with data protection, we need our own internal developers, and it's possible. So, and that's the direction we are taking, borrowing from the industrial court, because I was impressed when I went there. They took me through what they have done, and it's amazing. These are young people Ugandans who they brought on board. So we can no longer afford to risk some of these things because of, as you have noticed, in artificial intelligence. But let me talk to uptake. We had a conference of chief magistrates. I asked them to log in CAS. Only one person was capable of doing that. This is CAS which we use, which is our only one. This was in Mbare. I said, Any of you who can log into CAS, put up your hands. Only one person did. These are chief magistrates. Judges, we were in a judges conference. I asked our quarterly performance review. I asked them, those who had passwords for CAS. I think it was only Justice Ketirima who put up his hand, but someone else. And I was even surprised that some of the senior judges could not put up their hands. I remember very well. So how do we, because these systems, we bring them on board, and then Nexus, can you imagine 4%? And we are spending a lot of money, 4% uptake. And yet it has all the capabilities to assist us in so many things. So how do we move to utilization? That's a question we need to look at. Of course, Justice Sonora raises fundamental. I think my job is now cut out. I know how I'm going to go into guidelines, into the policy, all that. So why reinvent the wheel when Justice Sonora has already done the work for us? So I will be knocking on your door. And I think the issue of Estonia, I have already asked Justice Madrama, who is the head of our team, to look into that, so that perhaps maybe since you are going there in April, Justice Madrama should be able to also arrange that. Or maybe if you get enough, if you find we don't need to go there, we can come to you actually instead of going to Estonia, which is very far. So thank you so much. And I think that's what I thought I should talk about.
Thank you very much, Chief Justice. Justice Mliagonja.
Thank you, Chair, and I would like to thank all the presenters for the way they've exposed this whole myth. To some people, it's a myth, the myth of AI. Because these days, whenever you open a computer, somewhere there's some advertisement about AI. Now, mine is really a comment. I'm not going to ask a question. I want us to think about addressing the people. We have systems, like Justice Egonda has said, we've had two systems. We had CAS, now we have ECMIS. Now we are bringing in other databases. One of them is our own, which is huge. Then we are bringing in Nexus, which some people call Nexus. Bringing in two databases, it's a lot of information. We have grown as a judiciary. We are all at different levels of knowledge and use of computers. We are all different kinds of individuals. Now, what is happening in the judiciary in Uganda, and I don't think it's just the judiciary, many organizations or many MDAs and government departments in Uganda have started on this journey of using computers. We have statutes and all those things. The one thing that we fail to do is address the people. You cannot have a system operate itself. It has to be operated by people. Now, if these people are not trained to utilize these resources, don't expect a judge. I am myself, I have a certain knowledge about the use of computers and some of these databases from my knowledge that I gained when I was in university. Not everybody gets those opportunities. So I want to say that unless we move together, and there's no way we can move together unless there is training and on-hands training. People fear the mouse, my friends. People fear the mouse, the real mouse, this one which moves. And then now you have these mouses which are on the computer itself. They are the ones which are like a little ball. Then they are the ones which people need to be trained And that's where we have to go. Because if we sit here and just talk and talk, we are theorizing. It's just a talk workshop and nothing else is going to come out of it.
Thank you very much, Justice Muriagonja. Let us take Pito and then Your Worship Kawesa. We are stressed for time. So Pito, I'll give you 1 minute. Your Worship Kawesa, 1 minute.
Yes, thank you very much, Chair. Application of ICTs, of AI in justice works. This can be tackled through two perspectives. One is detailed, the use of AI as a support tool. However, also AI, we have to look at AI as a subject of judicial proceedings, where we have, for example, driverless cars, we have drones, we have medical diagnostics, as well as treatment systems. Usually in such systems, we see that we see that quantification of damages and liabilities, which is traditionally referred to human behavior, has to be looked at. So those are the two perspectives in which AI is applied. One is detailed, whereas AI as a subject of judicial proceedings. We also have to tackle one aspect of, do we really need AI? We all agree, yes, we need it, but we have to use it in compliance with judicial requirements. The other, Chair, we also need to observe that we are moving from manual to computerization to digital transition and now to arithmetical algorithms where AI is applicable. We need support, as Justice Muriagonja has pointed out. We need support to enable us support as well as move from this stage to another stage, as well as embed AI within our system. So it's a stage that the judiciary has to support in order to be accommodated.
Thank you very much. Your Worship Kawesa, 30 seconds now.
Yeah, thank you very much, Chair and members of the panel, for that wonderful presentation. Yes, the name is Godfrey Kawesa, Deputy Registrar ADR. And a very quick one, a comment that the world, in organizations the world over, there is what they call resistance to change. And their success depends on how best they overcome that resistance. So I just want to make a comment that AI is here to stay. Let us not stigmatize it, because there's a tendency, to stigmatize those ones who apply AI. But AI is here to stay. And the good news is that on the 8th of December, 2025, just last year, the United Nations, finally, the United Nations Education, Scientific and Cultural Organization, UNESCO, came up with 15 core principles of how AI can be applied in the courts. So, my lords, I would implore judiciaries in Uganda, East Africa, and the world to emulate these principles, and we apply AI. Otherwise, I'm also the author of the book on AI and how it can apply in Uganda. I thank you very much.
Your Worship Katushabe, 30 seconds.
Thank you, my lord. I'm interested in how we take on this journey from here to use AI, how to protect our machines that we use. I say this from experience from other organizations where they have computers, phones, and tabs that are specifically used for work, and you're not allowed to use them for other things because of the fears that have come with AI. How do we put security measures? Because as you said earlier, AI does the heavy lifting, the work that bogs us down, the summaries, the predictive analytics. It does the work that would have taken a lot of your time and then gives you opportunity to think and give a decision. So my question is, what do we take on from that?
And also a little bit of concern of what happens. I find that most of the time people prefer to use their Google email other than the official email. I think it's time that we need to have a policy around using official emails to avoid the fact that AI picks data. Everywhere you put your things, it's picking information because it relies on data. So it's as we make a step to saying we want to take AI, we need to do as an institution so many things to put in place to ensure that the data we have is protected, and we can use the predictive analytics for ourselves instead of the lawyers predicting us and knowing what decisions that we can make. It helps me to know that actually for the last 2-3 years, these are the sentences I give, this is how I decide, and how I can improve that. Thank you.
Thank you very much for your observations. I will ask Justice Chiragwire to attend to one aspect of Her Worship Katanga's question.
You raised the issue of data that we have incorporated in VHS tapes, and that other people would like us to have a copy of it. My simple solution to that is you duplicate the VHS tape and give it to them, but enter into an information sharing agreement or MOU as to what they can do with it. It is there are even open source tools that allow change from one format to another format. So that's what you can do. But I think whenever someone is asking for delicate information from us, we should have a kind of MOU as to what they can or cannot do with our information if we agree to share it. So keeping the chain of evidence is important. That is the best way we can do data protection. And I know there's some people with old equipment which still duplicate VHS to VHS. So I think some of those can be looked for, and they do it. I don't think Makerere would be a very good source to do that. But there are people in town, those who have the old equipment, which actually do duplicate VHS to VHS. These are the old things, by the way. For those of you who are not happy with this format, remember how we used to put that huge tape into the videotape? That is called VHS. So we have all used it. There's nothing big about that format. Thank you. But also, let me just say something about utilization. I think what I have learned the time I've been in technology in the Ugandan judiciary is this, that people are doubting Thomases. It is only when they have touched the wound, or someone else has touched the wound and has benefited, that someone else will what? Come along. So we need to have champions who push the agenda. We say a lot more, but time is not our best ally. Thank you.
Thank you, Justice Chiragwire. And one comment from His Worship Wegoye.
As it has been said, AI is here to stay, but I would like to speak to 3 aspects.
One comment on 3 aspects. Yes.
The judiciary has invested so much in both LexisNexis, Yuli, and ECMIS. I pray that we understand the capacity of these systems and make use of them. Currently, I believe there is no excuse any judicial officer should have not to know anything about technology or the use of AI.
Thank you very much, Your Worship Wegoye. Our lived experience as we bring this session to a close, Justice Muryagonja, is in-house development has allowed us to be involved in the development of the AI as judges. When we have a challenge, we speak to IT, and by end of day, IT comes and discusses the AI solutions, options that we have come up with. So we are involved. The idea is the AI is developed by us, for us. It is not alien, It is not Microsoft, it is by us, for us. So we can talk about solutions to a challenge we faced at 9 at 3 p.m. So I agree with you, it is about awareness. Can we be made aware? And time allowing, we would be able to demonstrate, Chief Justice, at an appropriate time, what Alfie can do with your record of appeal. This is real. Feed in your record of appeal and you will get a summary. So it is a lived experience. We are experiencing it. My Lord Chief Justice, Principal Judge, please join me in thanking the panel and Justice Isaac Lenola for a very riveting session. Thank you very much.
We thank you too, my Lord, for chairing the session. Let's please give him a big hand of applause. Like it's been said, AI is here to stay. We shall do our best to stay with it in the same room and use it. My lords, we are going for break tea. It's going to be a 30 minutes break, my lord. But as we step out, we have I'm sorry, I've been guided by the Honorable Chief Justice that we should have the next session briefly, and then we go for break tea, my lords. As I have been asked and instructed to inform you, my lords, that we have officers from Housing Finance Bank. They're here to teach us and train us about financial wellness. They have flyers that they are giving around. Let us please visit their stall, my lord, or they can come to you and talk to you about financial aspects, as we believe that finances are part of the judicial well-being. Without further ado, my lord, the Chief Justice, I take the honor and opportunity to invite Honorable Lady Justice Elizabeth Musoke, the Justice of the Supreme Court, who is going to chair the next session, my lords, before you go for break tea. Thank you very much. My lord, we have been guided that we have that session before you go for break tea. Yes, please, my lord. My lord, I request that you please take your seat and chair the next session, my lord. My lady Irene, I'm trying to call the meeting to order. No tea, no tea. Tea will be after. Yes. Can you please release
Our main guest. Yes. Ah. My lords, your worships, the officers, invited guests and officers of the judiciary. We had been informed that the tea will come first. I hope people have not gone. They've not gone for tea. How can I summon them from here? You're here, alone, and frightened. Okay. We shall start with whoever is here. Yeah. Good morning, everybody. Let it be an informal session. I'll call the CJ on my left. I'll call him Alphonse. Good morning, Alphonse. Morning, Richard. Not when I want to be informal. Yes, so you want me to call him Kavuma, not the informal name? Yes, okay, we can start now. I think we have little time. I'm chairing a two-person session. Luckily for me, the others have been many panels. I don't know if mine can be called a panel of two. Is it a panel? Okay. A panel of two. Can I call my panelists? The one whom I'm going to grill, whom you are going to grill? PS? No. I'll call him Pius. Pius, can you come forward? And sit first before you go to. So let's try to be informal right now. It's the last day. Yeah. So I don't know. I don't think I can introduce myself. I don't know who should have introduced me, but me, I'll do my job and introduce my panel. Nobody has bothered to introduce me as who I am, but I'm Elizabeth for today. I'm Elizabeth. My panelist is called Pius. The other name is Bigirimana, but for today we shall stop at Pius. I'll just tell you a few things about him. Not so much, of course. His CV is very long. If I started on it, probably it will take all the time we have. So Pius is the permanent secretary to the judiciary and accounting officer of the judiciary. He has been so for over 5 years. That's so far. Yeah. Currently, Pius is a chairman of the Southern and East African Judicial Administrators Association. It's made up of 14 countries, and he is to be there for 2 years. It's not a mean task. Better clap for him for having attained that level. Yeah. He has been in government for 40 years. As you see him there, he has been in government for 40 years. 17 of them as PS in various ministries. That is Office of the Prime Minister, Gender, then the judiciary, where he has been for quite some time. He is a holder of 2 master's degrees, one in social and economic policy, and the other one in business administration. You've been seeing that he's been called Dr. Pius, Dr. Bigirimana, but that one is an honorary degree. He did not do any research in that respect. He was awarded that because of what he has done in the service. So he's doctor, but at some point they said that doctor should not be used, should not precede any person's name, and I think he has really abided with that. Right now, he's a doctoral research student. So he wants to earn the doctorate to be called Dr. Pius without anybody asking him, is it honorary, is it what? And he's about to finish. You are going for your vivas, not so? Soon. He's a research student in administration and management at UMI. He has published a number of books, and most of you have read some of them, notorious of which is The Naked Truth. Many of you have read that one, about the naked truth, although you don't want to admit that you've read it. And you've learned a lot in that book. But he also talks about wellness. Yeah? Immediately, Pius came to the judiciary. He introduced the wellness program. You all know this. He really was very, very about this wellness. So there is a health club. People engage in aerobics every Wednesday and Friday. Everybody in the judiciary is supposed to do it now. These are still ongoing, but at the new buildings, you also have gyms, state-of-the-art gyms, which were instigated by him. We thank you very much, Pius. I think that will do, although he has, it's really very big. I've just decided to point out a few of those. Now, Pius, although this will not be like the normal panel discussions people have had, but we also too, so we can make ourselves into panelists, where I'll be asking you questions. Yeah? I'll be asking him some questions, because when the new the new administration of Justice Act was ushered, it ushered in a new way of managing judicial work, as far as human resource was concerned, financial resources and others. And the PS is really the one who is responsible to see that many of what is there is implemented. And he has done a lot. What I can say is that our PS here, when they had just come, I don't know if even now they say is so, they were introducing him as quinine. He's a quinine, and moreover, not just quinine, but quinine without sugar coating. That is Pius. Quinine without sugar coating. But as you know, okay, we may think that quinine is a sour pill, but if you are sick, and you take quinine, you get well. So Pius, thank you for being the quinine, especially without the sugar coating, because you really made us well. Thank you so much. I'll go into the questions. Question number 1. After this, you can also ask some questions, but these are mine to him. The judiciary's budget has increased from 199 billion in financial year 2020 to 2021 to 435 billion in financial year 2025 to 2026. Despite the increased budget, the resources are not being felt in the ports. Why?
Well, I have a duty to answer the question. It is true that the judicial budget has increased actually by 123% over the years, from 199 billion in 2020, 2021 to now 441. However, it's not true to say that the resources are not being fed in the courts. The allocation of resources is geared towards improving the performance of the courts. And these are the areas that I want to talk about to show that actually there is impact which is being felt in court. Let's start with salaries. The wage budget increased by 87% from 58 billion to 108 billion to cater for salaries of judges and the enhanced salaries of the lower bench, the recruitment of additional judges, registrars, magistrates, and administrative staff. 2, statutory allowances. Judicial allowances for the lower bench, non-judicial staff allowances, session allowances, and duty facilitating allowances, which increased from 22 billion to 68 billion, marking a 209% increment. And the budget has increased over the years due to the increased staffing and coverage of courts. For example, the total number of judicial officers in the financial year 2020-2021 was 390, which increased to 706 2025-2026. Number 3, institutional development and retooling of courts. The budget has increased from 21 billion to 56 billion, which marks 167% increment. And this includes construction of new courts, provision of transport equipment, vehicles, motorcycles. I don't know whether there is any judge without transport. I doubt. Many courts have got motorcycles, alternative sources of power. We have increased the provision of solar. Number 4, operational expenses increased as a result of expanded judiciary, as detailed here. 1, automation of courts, including the rollout of ECMIS. In 2020-2021, these were not there, except the CAMS, but the ECMIS now. Internet connectivity, video conferencing, and online legal reference materials. We've been talking about Nexus. Now the current budget is 20.7 billion. Renting for courts. The rent is now currently at 11.2 billion. medical expenses, including medical insurance, which moved from 0.7 billion to 5 billion. Maintenance of judiciary fleet moved from 5 billion to 14 billion. And the judiciary fleet has increased from 175 vehicles in 2020-2021 to 370 vehicles in financial year 2020-2022. My lord, the vehicles have been given to all judges, justices, all registrars, deputy registrars, a few maybe, one or two, assistant registrars, chief magistrates, magistrates grade 1 who's in the hard to reach areas. So we have got transport, although we need more. Guard and security services increased from 3 billion to 5 billion. Utility, that is water and electricity, increased from 1.5 billion to 2.3 billion. Then 2.3 billion for other meetings, like a judicial council, committee meetings, all of this. We have then retirement benefits. The budget increased from 15 billion to 34 billion. That's a 123% increment. And currently we have got 250 retired judicial officers receiving their retirement benefits and on time. So it is not correct to say that the budget increased but it's not being fed. It's being fed too much. It is raining. Very soon there will be thunderstorms.
Okay, Pius, the judiciary's finances, human resource, and infrastructure have improved over time. But is the judiciary delivering according to its resources?
Of course, the Chief Justice yesterday was very clear. Chief Justice Emeritus has made it clear every now and then. The performance of the judiciary has improved gradually. And according to the annual performance report, the total number of cases completed increased from 156,875 in 2020-2021 to 259,331 in the financial year 2024-2025, translating into a 65% increase in number of cases disposed. However, according to the Auditor General's report for the financial year, which ended 30th June 2025, he noted that maintaining the same or setting lower disposal targets and disposing of the same or less cases indicates that the change in variables like recruitment of judicial officers and increase in the budget did not have impact on annual disposal targets and number of cases disposed of. So I have been put to task whenever I go to Parliament. They have put me to task to explain the anomaly and consider revising the annual targets, taking into consideration other factors like increased recruitment of judicial officers and funding. So whenever I go to Parliament with the Chief Registrar and staff, really this is a very, very big question. And in addition, the Parliamentary Committee on Legal and Parliamentary Affairs has time and again raised critical performance issues like the absence of judges at court stations, adjournment of cases more than 6 months, and judgment on notice that takes more than 5 months to issue. Judgment on notice. Why not? They ask me, why not set the date? You say you are going to deliver judgment on this date so that the litigants are aware. It is something that is really giving us a number of problems in Parliament. Then they threaten to cut our money. Now, their proposed interventions value for money adjudication. This is achieving the maximum results from the resources available. And the principle looks at economy, the input, and efficiency, minimizing waste, and effectiveness. And this is to what extent are the targets achieved or the outcomes met. For example, I have the privilege to read some session reports where performance does not match funds dispersed. For example, a session of 40 cases and only 20 cases are completed. And then 20 cases are adjourned to next convenient session. And yet the process, the funds have been spent on process serving, on witnesses, on stationery. All the money has been spent, but the cases have not been disposed of. So I've been threatened that I'm going to pay that money. And you know yourselves, I'm not going to mention the courts, but there are courts which have been habitually not delivering, but money is spent. So I've got a problem. You help me. If you take money for 20 cases, 20 sessions, you deliver. If not, I think I'm going to extend this query to you as a court and to the registrar of that court to explain or pay back that money.
I was thanking him for the answer. The government launched the 4th National Development Plan, financial year 2025-2026 to 2029-30. This is NDPPIV. And the plan acknowledges the judiciary's role in the socio-economic transformation of Uganda through advancing access to justice. What plans have been put in place to achieve these objectives?
My Lord, the 6th Judiciary Strategic Plan has been aligned with the 4th National Development Plan 2025-2026 to 2029-2030. And the judiciary will focus on advancing access to justice through the following. 1, improving case management. 2, improving coverage of judicial services. 3, promoting digital transformation and automation of court processes. When the Chief Justice yesterday was telling you paperless courts, this is not just a threat, it's real. You're going to have it. We are not going to buy paper. If you buy paper using your own money, that's your business. But I don't think that Minister of Finance will agree to have an item of stationery approved. 4, enhancing human resource development. 5, strengthening integrity and accountability. 6, strengthening strategic partnership and resource mobilization. And 7, improving performance management, statistical development, and monitoring and evaluation. And I think this is where the Chief Justice was emphasizing delivery unit to make sure that what is being done is supervised and reports are made timely. The judiciary has been, this on a good note, the judiciary has been awarded a certificate from National Planning Authority for compliance with the 4th National Development Plan. We got it on Friday. And a copy of the new strategic plan will be distributed, or it has been distributed. You must have found some of these copies in your bags. please read, internalize this strategic plan. It is yours. So the moment you get any challenge, don't hesitate to ask for assistance.
Thank you for that answer, Pius. Now, in light of the theme for this conference, which is Judicial Wellness, a tool for effective case management, what plans and strategies are in place to improve judicial wellness? I know you've done some, but what other plans do you have to improve it?
My Lord, I will emphasize those which you already know and the new ones. Number one, the judiciary will continue to implement the current initiatives towards judicial wellness. Provision of medical allowance for justices and judges. This is being received monthly and will continue. Medical insurance cover. Judiciary provides, I think judiciary is maybe the only institution apart from Parliament which gives insurance to its staff. And this insurance has helped greatly. Justices and judges are required to make a contribution to benefit from the insurance cover. This is because you get monthly medical allowance in line with the Salaries and Allowances Act. 3, psychosocial support. Services are available. Those of you who don't know, I think it is time to take note that we have got a provider, Rapport Counseling Services, located at Kampala Medical Chambers on 4th floor Buganda Road. This is aimed at improving judicial wellness. Please kindly go there. If you find in privacy, you go there at your own time so that you don't attract people's attention, and you get counseled. If you have got domestic problems, you go there. Social problems, even financial problems, even stress, go there. And I have got reports that people have been going there. Number 4, gym and health provisions. These facilities are in place at Supreme Court and Court of Appeal building, and they were put in place with the aim of improving staff well-being and productivity. But it looks the performance is not very, very good. When I go there to check, I find a few have recorded they have attended, and then you cry that you have got problems. You suffer if you don't go there. These facilities are there. Use them. Use them. Then we have got health aerobics. And I'm happy to inform you that the Chief Justice and the Principal Judge have been leading us every Wednesday and Friday. Thank you so much. You are leading by example. You know, when you go there, the other judicial officers get attracted, and you give encouragement. And I'll be joining you. My foot is almost, although the Chief Justice Emeritus has warned me that I should not go to do exercise until I have recovered fully. But I'll go there tomorrow to boost my staff also. I'll be coming at 5. Number 6 actually, judicial HIV/AIDS workplace policy. The judicial HIV/AIDS workplace policy provides a framework to guide in preventing, managing, and mitigating the effects of HIV and AIDS among staff of the judiciary. And the judiciary currently, by the way, supports more than 45 people. We do support those who are affected, and we counsel them. So don't fear to have your situation handled. Then the judicial anti-sexual harassment policy. This policy provides a framework for awareness creation, investigation, and handling of complaints of sexual harassment in nature.
Oh. Some of us didn't know it exists, but well and good. The introduction of the medical insurance cover is beneficial. However, there are those officers or people who work at the judiciary who may have illnesses which require being treated outside of Uganda. Right now, it's almost impossible under the current medical cover. What plans do you have to assist those genuine cases who require treatment outside of Uganda? To elevate at least the medical cover
My lord,
to that level.
for the case of insurance, specifically Jubilee Insurance does provide medical insurance in all the 3 East African countries. They have contracts with most facilities in East Africa, and the Aga Khan is one of them. On referrals by Ugandan hospitals to India or Mauritius, Jubilee has to be notified to make proper arrangements. But besides this insurance, government has got a policy to when people are referred out, and the medical board has cleared. I have on a number of times got medical board clearance, and I have written to finance, and the finance has provided funds for treatment abroad. Many of you have benefited from this. So if you visit a foreign country and happen to access a facility and you have got an insurance, a Jubilee insurance, on your return, you are required to submit all your paperwork for refund within 6 weeks. At least that's the arrangements we have with these insurance companies. And if you have got any questions or more clarification that you need, I have tasked the Commissioner of Human Resource to be available. You can get in touch with her. She will give you more details.
Thank you, Pius. As Secretary to the Judiciary and Accounting Officer, can you tell us maybe some other 3 things that you can share with the justices and judges and judicial officers around?
My lord, I will start with health of the judicial officers. You know, health is wealth. And I want to request you to prioritize it. I want to invite you to read my book, The Naked Truth. And in particular, chapter 14. Please read that chapter 14. That chapter 14 is giving you some advice on how to eat, what to eat, when to eat it, minimizing alcohol because it affects your health. I told you that you shouldn't drink as if the breweries are closing that day. Be moderate in your drinking, and above all, do exercises. So the first is to advise you to take your health very, very seriously. Nobody will save you. You save yourself. Number two, value for money adjudication for the judiciary to meet its targets. Because this is the business you are in. You are employed to deliver justice. So, and using minimum resources and avoiding wastage. Number three, the judiciary is critical in the socio-economic development. And yesterday the Chief Justice talked about prioritization. My advice is to look at these cases with the lenses that see the usefulness of getting these cases out of court, because there are implications for the economy. So that is those are the three pieces of advice I would give to their lordships. I thank you.
Thank you, Pius. Can we give a hand clap for him? Now, I think we shall. Are you the chair here? Who is giving us the time for questions and answers?
My Lord, thank you. I think now we can just do the plenary because we also have to check out. And it was supposed to be 11. Maybe you could take some 2 questions from, yes. Yes, yes, after this. So you can just invite 2 questions.
Thank you, my Lord Chair and the presenter. Mine is a comment on IT. Whereas it's now a fact that we can not run away from IT. When we start talking of paperless and then you are saying the budget might be extinguished for use of paper, to me, this should be, paperless should be equal to less paper, but not no paper. I was talking to Mr. Ekimis here. For him, he breathes, thinks and drinks Ekimis, whatever he is. The possibility of doing without paper is not anywhere near soon. Even the economies that were there before us have not achieved this. So when you are thinking of uptake of IT, you temper it and know, yes, IT is good, it's very helpful, we can run away from it, but let us gradually, to avoid the shocks that come with it, reduce the use of paper, more of IT, but you can't say paper less or no paper. Let us use less paper, but let us embrace the IT. I thank you.
Thank you. Mine is to the PSSJ. And it is on prioritization of available funds to meet the judiciary's core mandate of adjudication. There is a feeling that at times we have not utilized the resources that come to us to do adjudication. At times it is put on other matters. So what would you say to that? Because when it comes to sitting to allocate funds, judges don't sit in that committee. They send registrars. And at many times, these registrars listen to you more than the views of the justices. Because when they come there, they say, I think we should put money here and there. And we feel that maybe our views are not taken into account.
My Lord, thank you also, SJ. Mine is about the medical, foreign medical cover or treatment expenses. You just mentioned that I know that the insurance might cover East Africa, But you mentioned that when you go out for medical treatment, you can spend your money and get carry your papers and come back in 6 months and get a refund. I think that should be qualified. That requires prior authorization by the insurance, because otherwise you risk judicial officers going out there and coming back to file suits against the insurance, because they will not give you unless you have had prior authorization with the insurance.
Thank you, Lady Chair and PS. I'm just seeking for clarification from the PS. Given what is happening, Article 128(5) of the Constitution states very clearly that the administrative expense of the judiciary, including allowances, gratuities and pensions for judicial officers, shall be charged on the consolidated fund. And that means that the expenses in this case, the administrative expenses, including the judges' allowances and salaries, are directly funded by the government without needing annual appropriation by the parliament. Now, we very often have challenges where the salaries are delayed. The allowances, we have had the normal, the routine payment of housing allowance for 3 months, but we have already received a notice to the effect that they will only pay for 2 months, January and Feb. But we believe that that money is released quarterly and it does not have to go through appropriation. I'm just seeking clarification what is happening and what will happen to the judges who pay rent for 3 months, because that is what their landlords know. First of all, it has delayed, and then just imagine that explanation that, oh, it has delayed, but in any case, now I can't pay for 3 months. What happens? Well, what is happening?
We shall have Pius answer those questions.
I will start with the last. Justice Mutoni. You know, when the Constitution provides that money will be charged on the consolidated fund, the assumption is that that fund will always have the money. But remember, we are managing cash economy. Our budget is financed from the cash that is collected. Now, if the Minister of Finance has not collected enough cash and the money is not on the fund, where do you expect finance to get the money from? So always be understanding when the money is not forthcoming. There is very good reason for that. The last but one question was on medical cover. Yes, it was just advice. I think qualification. You are right. You have to inform the company so that they know you went out. Then the second question was from Justice Borion. Prioritization, that there is a feeling. Indeed, it's a feeling. It's a feeling, but it's not necessarily true. Because we sit in our finance committee and all registrars of various courts are represented. And I assume that these registrars come with the instructions from you, because you are supposed to meet as a court. If it's a high court, if it is a Supreme Court, Court of Appeal, you meet as judges and tell your registrar what is a priority. Now, these priorities are presented, they are put on the table. But depending on the money that you have got from Treasury, the money is distributed accordingly. And everything is put on the table. There's no money that stays behind. Even me as a PS, even the Chief Justice has got his allocation. It's known to him, and every time we communicate. So the beauty of it is that the transformation which the Chief Justice Emeritus brought in place was to have these organs that sit and discuss matters of finance. Finance Committee, Senior Management Committee, Top Management Committee, in a transparent manner. Lastly was the first question from Justice Gash. I want to advise you to psychologically be ready. This is not a joke. It will be gradual, but you should you should know that we are heading towards that. There will be no paper. So the earlier, the better.
Thank you very much, Pius. I don't know if Honorable Chief Justice would want to say some final.
No, really, I don't think I have anything to say. Let's bring it to a close so that people can go and check out and then have tea so that we conclude the session.
Those who have questions can see him
Yeah,
personally outside.
Yes.
He can answer. Yeah, he's available to answer outside. So, final round of applause to Pius and to me also.
Thank you so much, my Lord Justice Elizabeth Musoke and Pius S.J. Thank you so much for that presentation. I think just to take into account checking out, we can add on to the 30 minutes, we add 10 minutes. So we go for a break of 40 minutes. My Lord, is that okay? 40 minutes, and then we are here at midday, 13 minutes past midday. 13 minutes past midday. So you have 40 minutes, my lords. Thank you so much.
No.
My lord, you may recall that in 1776, the father of modern economics, Adam Smith, propounded the theory that one of the most important factors of production in an organization is the human resource. Yes, the Uganda judiciary has put in place the hardware, like the buildings and all, but it had not given a lot of attention to the human resource.
There's loss of pleasure. If someone is not well, they will lose interest in what they are doing.
My lords, I'm pleased to present the High Court's performance review for the year 2025 and informed by the recently released National Court Case Census of 2025 and related judiciary performance data. Number one, high workload concentration at the High Court requires continued attention to case allocation and judicial deployment.
We are privileged to have with us esteemed speakers, including the Chief Justice of Zambia and colleagues from the appellate courts of Kenya, who will enrich our discussions with regional and global perspectives.
On behalf of the judiciary, I extend a very warm welcome to you to this occasion of the official opening of the 27th Annual Judges Conference. I also equally welcome all our esteemed guests to this auspicious occasion. This is not just a routine institutional gathering. It's a solemn pause to examine and reflect on what we have been able to achieve, what we have not been able to realize, and why. Allow me to use this opportunity to request the Permanent Secretary, Secretary of the Judiciary, and the Chief Registrar to ensure that this day is observed annually by the Judiciary. I extend my boundless gratitude to the Executive and the Parliament of Uganda for their continued support, and to all judicial officers for your sacrifice and dedication in serving the people of Uganda. With those few, are they few? It is now my singular honor to invite Your Excellency, the Vice President of the Republic of Uganda, to talk to your people and officially open the 27th Annual Judges Conference 2026 for God and my country.
Our 1995 Constitution is clear. Judicial power is derived from the people and must be exercised in their name, in accordance with their values, and for their benefit. Justice must therefore be accessible, timely, impartial, and respectful. First, the Africanization of justice means grounding our legal processes in the realities, values, and wisdom of African societies. I also wish to congratulate His Lordship, the Chief Justice, the Honorable Dr. Flavian Zeija, upon assuming this important responsibility as the new Chief Justice of Uganda. I trust that under this leadership, the judiciary will continue to align its work with national development priorities and play its role in the transformation of Uganda. As you deliberate during this conference, I urge you to focus on practical solutions that reduce backlog, improve turnaround time, and strengthen public confidence. Every completed land, commercial, and criminal disputes enhances the economic development of our country. The Wananchi are watching. They want results from you. I thank you for your service and commitment to the country. And ladies and gentlemen, my Lord the Chief Justice, it is now my honor to declare the 27th Annual Judges Conference officially open.
The timing of referrals is very, very critical to avoid unnecessary litigation. because there are matters such as boundary disputes. Probably people are contesting over a few decimals, not even a meter or something small. And therefore, instead of having people litigate endlessly on that small matter, we can actually divert that matter quite quickly.
A true lesson is only learned when it results in a tangible change in behavioral process.
Now, if a judge can restrict him or herself to those issues and guide the parties to addressing you on those issues, then you automatically take out the drama that comes with election petitions. And then in my view, you're able to actually control the proceedings and take out all the nonsense that tends to accompany that.
Should not be assessed from very technical perspectives of we who are trained in the law. We should place ourselves in the feet of the ordinary voter, ordinary participant in the election. Would this evidence satisfy them that an electoral offense was committed?
So you as a judicial officer, what is the level of your satisfaction? There are people you touch a bit like this and they are satisfied. There are people where you have to do a lot of cajoling and convincing in order for them, some form of judicial foreplay enough to make them understand. So if the standard is that it must satisfy court, then it comes to each individual judicial officer's discretion. And that is an area that we have to watch out for.
If there was a situation where judicial wellness is called for, it is the determination of an election petition, more so a presidential election petition. And I've gone through all those motions. I have seen it all. And so I thank God that I'm still here to talk about a presidential election petition judgment writing and judgment writing in other election petitions. So please join me in clapping for the Lord Almighty. And again, this I'm picking from what has been stated by the panel. We have been told that we should disengage emotionally from the judgment. We must just stick to the issues, the evidence, and the law. It must be well reasoned. This is the lesson that we have learned for ourselves, that it's clear and concise, well structured, legally sound, and well reasoned.
Any one of us here will suffer a stroke if you don't do the following. At our age, it is absolutely necessary that you get yourself in some form of physical exercise 3 times a week at least. That's what is recommended. Minimum 45 minutes. So do not fall into the same trap. Imagine all those responsibilities, and I was sleeping maximum 4 hours a day. I brought it upon myself. Please don't do that. I beg of thee, do not do that. Okay? There's a lot more to this work that we do. Let's first look after ourselves. I thank you, ladies and gentlemen. Any one of us here.
Finally, we are realizing that we have to pay attention to the most important part of production, which is human resource. And when I look at other jurisdictions, the Caribbean Association of Judicial Officers had this to say, that judicial wellness and well-being is not only about the happiness of judges and the non-judicial staff, but also healthy judiciary systems. Policies must be healthy. Finally,
as we participate in this conference, let us remember a well-supported judiciary is a stronger judiciary, a healthier judge is more effective, and a resilient and attentive support staff contribute to an effective judicial system. As a resilient judicial system is one that can truly deliver justice for all. Let us use this opportunity to learn, to share, and to commit to a judiciary where wellness is woven into every fabric of our work for the benefit of ourselves and those we serve. I wish you all very fruitful and empowering deliberations. Thank you very much.
Spiritual wellness is also very important. And this does not necessarily look at religion. It encourages you to find meaning and purpose and things that you value. And through your religion, you can pray to the mighty power that you think and believe in for your well-being, and that will help you to feel better. Then we also have vocational wellness. I know you're judicial officers, but what you're doing, is it satisfying? Are you happy with what you're doing? Find purpose and make it interesting. Find satisfaction, fulfillment in what you're doing. Then we also want to encourage you to take notice of your environment and where you are. Be mindful. Practice mindfulness. It's very important. When we are here, for instance, you're in this conference, let your mind be here. Don't be in your courts and thinking about the pending work that you have to do. That is going to help you enjoy what you're doing here, interact with your friends, your colleagues, and share a moment of laughter. And don't be too serious, my lords and worships.
Pre-bargain has issues.
Spiritual wellness is also very important.
Pre-bargain has issues. The first and major challenge we have is we delay to deal with these cases. People the lists are given, but I think either as a result of lack of manpower or budget, we delay to attend to them immediately. And I think this is an institutional issue. We need to be ready to deal with them as and when. Actually, it's supposed not to wait. The other challenge we hear, which we have met along the way, is convicting or dealing with innocent persons who join this program. And they keep speaking to us. If you bother to ask, actually, may I have several examples if I had the time. They joined the program because of overstay on remand. And I think we should all plead guilty as judiciary. We delay to deal with them. So as a shortcut, they joined this program. But I keep preaching this. You shouldn't. Actually, even in the last camp in Kitaria, we had to chase away one, whom even with the DPP's consent, we discharged because there was no evidence at all. And the DPP was good enough to withdraw that matter immediately. But he had accepted, I think, around 13 years. And I mean, what an injustice is that? I would agree with Justice Alan Nshimye and the judiciary policy that it is a thing to do to deal with the elephant of backlog in the house. I thank you.
Thank you very much, Justice Tadeo.
The conference is deliberately designed as a moment of introspection to celebrate the milestones achieved over the past year, to candidly examine the challenges we have encountered, to extract valuable lessons from both our success and our setbacks, and most importantly, to forge concrete, actionable strategies that will propel us forward in the year ahead and beyond. Your Excellency, this year we have deliberately chosen the theme Judicial Wellness, as guided by the Chief Justice and members of the top management of the judiciary, a theme that speaks directly to the human dimensions of our noble calling. Judicial work, Your Excellency, is intellectually demanding, emotionally taxing, and often carried out under intense public scrutiny and pressure. By centering our deliberations on judicial wellness, Your Excellency, we affirm that a healthy, balanced, motivated, and supported judicial officer is better equipped to deliver fair, timely, and compassionate justice. A happy, satisfied, and resilient workforce does not merely sustain the institution, but it also elevates it, producing judges of greater wisdom, empathy, clarity, and moral courage. In turn, better judges are indispensable to meeting the ever-growing and increasing complex justice needs of our dynamic society.
Institutional and individual independence do not insulate us from accountability. The people of Uganda are the ultimate beneficiaries of our labor, and their confidence in our work can only be earned daily through fairness, efficiency, and ethical conduct. Only then shall we win the public trust that we badly need to execute our roles proficiently. Therefore, we must all guard against vices that bring the judiciary into disrepute, like corruption, absenteeism, poor customer care, poor time management, and undue adjournments and late judgments, among others. You know, it's so sad that people move and come to your court. They have traveled long distances, and then when they arrive at your station, you are not there. Or you arrive at any time you want. Let us all ensure that we have excellent court services based on the 3 pillars of hearing, death certainty, efficiency, and culture of service. Institutional and
I've already said I'm here as a representative. I do not want to water down the message of His Excellency the President, which I was sent with to deliver to you. Technology must reduce delays, not create new excuses. Alternative disputes resolution must decongest courts, not remain a side activity. Leadership at court stations must enforce standards. Timelines and discipline must be enforced. Judicial independence does not mean absence of accountability. I am encouraged that this conference will address alternative disputes resolution and alternative justice systems, case management in complex matters, sentencing consistency, technology, and judicial leadership. These are practical tools for improving performance and restoring public confidence. On alternative disputes resolution and alternative justice systems, let me be clear. Uganda has long traditions of resolving disputes through dialogue and reconciliation. Courts should not be the first stop for every dispute. Judges must actively manage cases and guide parties towards appropriate resolution mechanisms. This reduces pressure on the judiciary and allows courts to focus on serious and complex matters. Further, an efficient judiciary ensures that government programs are not unnecessarily delayed by litigation. It fosters a culture of patriotism by demonstrating that state institutions work with integrity and speed for the benefit of all the people.
Your Excellency, the Annual Judges Conference remains a cornerstone of judicial reflection, renewal, and peer engagement. It provides an opportunity for our justices and judges to pause from the demands of administering justice, to reflect on our mandate, Your Excellency, to also examine emerging justice trends and recommit to the highest standards of integrity, competence, and service to the people.
My Lord.
The timing of referrals is very, very critical to avoid unnecessary litigation, because there are matters such as boundary disputes. Probably people are contesting over a few decimals, not even a meter or something small. And therefore, instead of having people litigate endlessly on that small matter, we can actually divert that matter quite quickly.
A true lesson is only learned when it results in a tangible change in behavioral process.
Now, if a judge can restrict him or herself to those issues and guide the parties to addressing you on those issues, then you automatically take out the drama that comes with the election petitions. And then in my view, you're able to actually control the proceedings and take out all the nonsense that tends to accompany that.
Should not be assessed from very technical perspectives of we who are trained in the law. We should place ourselves in the feet of the ordinary voter, ordinary participant in the election. Would this evidence satisfy them that an electoral offense was committed?
So you as a judicial officer, what is the level of your satisfaction? There are people you touch a bit like this and they are satisfied. There are people where you have to do a lot of cajoling and convincing in order for them, some form of judicial foreplay enough to make them understand. So if the standard is that it must satisfy court, then it comes to each individual judicial officer's discretion. And that is an area that we have to watch out for.
If there was a situation where judicial wellness is called for, it is the determination of an election petition, more so a presidential election petition. And I've gone through all those motions. I have seen it all. And so I thank God that I'm still here to talk about a presidential election petition judgment writing and judgment writing in other election petitions. So please join me in clapping for the Lord Almighty. And again, this I'm picking from what has been stated by the panel. We have been told that we should disengage emotionally from the judgment. We must just stick to the issues, the evidence, and the law. It must be well reasoned. This is the lesson that we have learned for ourselves, that is clear and concise, well structured, legally sound, and well reasoned.
My Lord, the Honorable Chief Justice Emeritus, we want to congratulate you at the Commercial Court for your retirement from the position of Chief Justice of the Republic of Uganda. My Lord, we want to thank you for your distinguished stewardship of the judiciary since 2020 and for your steadfast support and guidance of the Commercial Division. More so, my Lord, we want to thank you for the re-engineering efforts of ADR, which has enabled the Commercial Court to be able to have mediators who are retired justices and honorable members of society working at the court to support the ADR effort. My Lord, we are confident that with such high caliber of mediators at the Commercial Court, we shall be able to reduce backlog largely and also to unleash the monies we are said to hold into the economy.
We wish to remember you as the ICD family for having, in your term as the Chief Justice, enabled us as the ICD to complete one of the first ever international war crimes and crimes against humanity case, the Koyero Thomas case, which had taken quite some time, but because of your effort, you facilitated its completion under your tenure. It's the first ever international war crimes and crimes against humanity case on the African continent and in this country, which was decided by a domestic court. We attribute the success of its completion to you, my Lord.
As you come to the evening of your service in the public service, I think it's worth celebrating, and that's why we are celebrating.
Justice Doro, I want to wish you a blessing in your retirement. I want to thank you for the guidance that you have given us at the JTI, the guidance that you have given in engineering alternative dispute resolution. I have worked with you closely on the activities of the Africa Chief Justice ADR Forum. I know how passionate you are. I know how other Chief Justices on the continent have celebrated you. And I am very certain that God will abundantly bless you for all that you have done, because justice is the attributes, in fact, is at the center of what matters most in the eyes of God. I am certainly very sure that you will enjoy your retirement and kindly allow us to run after you. We will constantly keep in touch with you. We'll be consulting you.
We wish you the best in your retirement, and we hope we shall continue to borrow from your experience and good leadership and richness of jurisprudence which you have already established. We wish you God's blessings.
My Lord, the Honorable Chief Justice Emeritus, we want to congratulate you at the Commercial Court for your retirement from the position of Chief Justice of the Republic of Uganda. My Lord, we want to thank you for your distinguished stewardship of the judiciary since 2020 and for your steadfast support and guidance of the Commercial Division. More so, my Lord, we want to thank you for the re-engineering efforts of ADR, which has enabled the Commercial Court to be able to have mediators who are retired justices and honorable members of society working at the court to support the ADR effort. My Lord, we are confident that with such high caliber of mediators at the Commercial Court, we shall be able to reduce backlog largely and also to unleash the monies we are said to hold into the economy.
We wish to remember you as the ICD family for having, in your term as the Chief Justice, enabled us as the ICD to complete one of the first ever international war crimes and crimes against humanity case, the Koyero Thomas case, which had taken quite some time, but because of your effort, you facilitated its completion under your tenure. It's the first ever international war crimes and crimes against humanity case on the African continent and in this country, which was decided by a domestic court. We attribute the success of its completion to you, my Lord.
As you come to the evening of your service in the public service, I think it's worth celebrating, and that's why we are celebrating.
Justice Doro, I want to wish you a blessing in your retirement. I want to thank you for the guidance that you have given us at the JTI,
the guidance that you have given in nearing alternative dispute resolution. I have worked with you closely on the activities of the Africa Chief Justice ADR Forum. I know how passionate you are. I know how other Chief Justices on the continent have celebrated you. And I am very certain that God will abundantly bless you for all that you have done, because justice is the attributes, in fact, is at the center of what matters most in the eyes of God. I am certainly very sure that you will enjoy your retirement and kindly allow us to run after you. We will constantly keep in touch with you. We'll be consulting you.
We wish you the best in your retirement, and we hope we shall continue to borrow from your experience and good leadership and richness of jurisprudence which you have already established. We wish you God's blessings.
My Lord, the Honorable, the Chief Justice, my Lord, the Principal Judge, my Lords, the Justices and the Judges of the Courts of Judicature, Your Worships, our Senior Administrators, we want to warmly welcome you back from the tea break. The time that was permitted by the Honorable, the Principal Judge is now. And we want to delve straight into our next panel. And I can see Justice Mike, I think, will be joining us shortly. I take the singular honor to invite the Honorable Lady Justice Professor Lillian Tibatemwa Echirikubinza. My Lord, the Honorable, the Chief Justice, there has been a few changes. As Justice Mike Chibita joins us, I take the singular honor to invite the Honorable Justice Emmanuel Baguma, the Honorable Lady Justice Rosette Kania Comfort, the Honorable Lady Justice Sarah Langa Siu, Her Worship Kaunde Khadija, yes, I have noted Justice Mike is on the way. My Lord Justice Mike, you're warmly welcome. The panel is already here awaiting you to kickstart it.
Very good, very good, very good. Thank you very much. Welcome back from the break. have our topic as judicial leadership and its impact on effective case management. And we have eminent judicial officers here to discuss the matter for us. Welcome with me, Honorable Justice Emmanuel Baguma, Deputy Head of the Criminal Division. Also welcome with me, Honorable Lady Justice Kania Rosette Comfort, Judge of the Criminal Division and Vice Chairman of the Judicial Service Commission. Last, but by no means least, Honorable Lady Justice Sarah Langasiu, Head Wakiso High Court Circuit. Welcome with me also the chair, who has been delegated by the chair. Your program says Honorable Lady Justice Lillian Tibatemwa Echirikubinza. As I told you last night, she's an administrative judge of the Supreme Court. So she has directed me to do it in her behalf. So welcome me as well. Thank you. We are going to start with, let me just check my AI, and then we go ahead. We are going to start with Honorable Lady Justice Sarah Langa. My Lord, we are here for the annual Judges Conference. Why should we be talking about leadership? Yet, judges are primarily adjudicators. And what is the place of leadership in case management? In 5 minutes, could you answer that question for us?
Thank you so much, my Lord Chair, my Lord CJ, my Lord PJ, my Lords, I greet you. And thank you so much, my Lord, for this question. I begin by saying, my Lord, that leadership is everything, because leadership is what makes or breaks institutions, families, communities. Anything is about leadership. And one of the most important things to note is that you may have the best plans, you may have the best strategies, but without the right leadership, whatever you have planned will fail. So it's not enough to say you are just an adjudicator. Leadership is part and parcel of a judicial role. Because the point is that any place of service is a place of leadership. So that means that all of us, the justices, the judges, the registrars here, magistrates here, wherever you are serving, that is a place of leadership. So in your docket, you are a leader. What only makes it different is the scope of our leadership, the sphere of influence. We know that there are so many levels. We have the CJ, the top management, who are leading us at an institutional level. But each of us, some of our leadership is limited to the circuit, to the division, to the registry, to the department, but also just in your chamber. You could be a judge and you're saying, for me, I am one of the judges in a division. There is the head and there is the deputy. But that docket of yours makes you a leader. So it's important that as we are here, we are talking about leadership as judicial officers. Now, this leadership is very important, my Lord, in case management, and that means that it requires us to be active managers, responsible for our cases, right from its filing to archival, meaning that we are involved in the full lifespan of a case. My Lord, as judiciary and judicial officers, our leadership must be hinged on our vision, our mission, and our core values. That is where we should be anchoring our leadership. So no matter the sphere, my Lord, as you exercise your leadership, keep this in mind. And I believe in the interest of time, we are all alive to the vision. Luckily, the new strategic plan has maintained the same vision of justice for all. It has equally maintained the same mission to effectively and efficiently and effectively administer justice. Equally, the core values have remained the same. I'm happy this morning we had the PS taking us through highlights of the new strategic plan. because as a leader, it is your role to understand this plan and be able to unpack it for your teams on the ground. Because, my Lord, as we will appreciate that leadership comes to all of us at very, very different ways. The top leadership has given us their vision, and we have had the benefit of listening to the Honorable Chief Justice unpack his vision. But we must pick that vision, run with it, and that is when it will have life. So it means we as leaders at the courts must be able to embrace it at all levels so that the leadership at the top is able to be felt on the ground. The PS also highlighted the issue of alignment to the National Development Plan. This is key, and therefore all of us in our different dockets, we have to ensure that whatever we do is aligned to that plan, and this is through the strategic plan. So, my Lord, just to emphasize is that the success of the judiciary begins and it ends with the leadership. And as leaders, let us run with the new vision, which is in the strategic plan 6, and that way we shall be able to deliver and be able to satisfy the desires of our people. Now, as I end, let me just highlight a few key principles of judicial leadership in case management, my Lord. One of them is the power of local control. What I mean by local control is the fact that unless at the local jurisdictions we unpack the vision, the mission, the core values, the strategic objectives of the judiciary will not be able to achieve much. It means as a leader at your level, it is important because at your local jurisdiction, you are, and we thank God, we are always called the principal judges. For judges, heads of circuits and divisions, we are the small principal judges there working on behalf of her lordship. Sometimes we used to have some magistrates who used to call themselves, they are the chief justices. Yes, indeed, they are the chief justices in those local jurisdictions. So that power that they exercise of unpacking what is at the center at the domestic or the local jurisdiction is an important principle in judicial leadership in case management. My Lord, the second is about proactive case management. My Lord, this has been talked over and over again, but the whole point here is that it is your role as a leader to set the pace of litigation and be able to drive it. My Lord Chair, one of the things that the new Chief Justice has always wanted when we have appeared in the quarterly review meetings is that we should adopt the prisons model. Prisons have their statistics of head. If you met them now, they will tell you, I unlocked with so many. This is where a leader should go, so that when they ask me, Wakiso, what have you unlocked with? I can tell you this morning, I've unlocked with 3,522 cases. Of those, how many are land, civil, and that? How many are backlog? How many at this stage? This is where we should be going as leaders. My Lord, last but not least, just let me tie this up, is I want to highlight the issue of stakeholder engagement. And my Lord, I want to pick one example from Lady Justice Harriet Magala. One of the things I discovered she does in her chamber is she has chamber engagements, chamber meetings. A leader acknowledges that even your office attendant is important in your final output. That driver must know that when you deliver that judgment, he has contributed to the administration of justice. And lastly, the issue of trial certainty. People, as a leader, you are expected that when you fix a date, people will find you. And when you say that this is going to happen in court today, it has happened. That way, as a leader, you are able to foster a case management culture that at the end of the day will also trickle down into mentoring even your teams. My Lord, I thank you.
Thank you very much. Let's appreciate her lordship. Thank you very much. Yeah, the thing about prisons is I have a friend, junior officer in prisons, who visits me in my chambers. And whenever he comes, he salutes and says, in Murchison Bay, we have 4,000. On remand, we have, and I find it very interesting. But I think they are trained that way. So now, my lords, when you are coming to see CJ or PJ, I think you have to come and as soon as you greet, you say, in my circuit, I have so many, and so on. Thank you very much. We now proceed to hear from Honorable Justice Emmanuel Baguma. Honorable Baguma, how does a judge's personal leadership style influence case disposal rates and courtroom efficiency in 5 minutes? Thank you.
Thank you, my Lord Chair. For the purposes of case disposal, judicial leadership is the ability of a judge to influence individuals or team members, or I can say the process and culture at the workplace in a manner that upholds judicial independence. Regardless of what your style is, every leader should display exemplary leadership to influence case disposal and courtroom efficiency. You must have the ability to influence, guide, motivate individuals, starting from the entry point when the case is filed and is concluded. How do we achieve common goal of case disposal? In my view, case management does not only require legal competency, but also it requires judicial leadership. I will share my personal style of leadership. One is leading by example. Leadership exhibits the highest moral standards to avoid preaching water and drinking wine. This will instill discipline in individuals and promote small court processes, which will reduce case backlog. When I was transferred from civil division to criminal division, I thought I was going for a break without knowing that I was jumping from the frying pan to the fire. But regardless of some of those challenges, I started with physical counting of files. Here I wanted to know my docket. I didn't want to start work without knowing what I have in my docket. So immediately I engaged the staff in my chambers and we started physical counting of files. Criminal division had started the ICMIS. So they were using both ICMIS and physical files. So with my staff, my clerks, my entire team, we did the audit of counting files in my docket only. At the end of the exercise, in my docket, I established that both ICMIS and physical, I had 400 cases. Now, after establishing that I had 400 cases, next, I decided, since it is criminal cases and they had started daily hearing, I decided to engage DPP, currently our principal judge. When I engaged the DPP, she guided me that criminal division handles cases from Kampala region office and Nakawa office. Now, I wanted to make my session successful. I decided to engage Assistant DPP in charge of Kampala region and Nakawa region. Here, when I went to engage them, I was armed with police case numbers and the police stations. So by the time I met this regional DPP, Nakawa and Kampala, I would tell them that Kampala region, you should have these police files from this station. Nakawa, you should have these files from this station. So we agreed. I gave them all the case numbers in my docket, separating different divisions. Now, after DPP, I had to engage Ruzira. I traveled to Ruzira to engage prison. I took the list of 400 files before me. In Ruzira, they have already talked about it. They are very accurate with data. Here, they were able to tell me, out of these your 400 cases, some were convicted during plea bargain, others have since passed on, others jumped bail. Now, I went back with the data from Ruzira. I looked at again the 400. Again, I established the files that had been transferred to Wakiso and Entebbe. At the end of it all, I found that out of 100, I was now remaining with 300 Southern. So through this engagement and this leading by example of physical counting of files, I was now from 400 to 300. I was listed those 100 called DPP in one day. We closed off those files. So I started with the 300 in my docket. So leading by example here, it helped me to engage and dispose of those cases. 2, effective communication. Communication is vital. You need to communicate your expectations and foster avenues for feedback from team members. Meet periodically so that issues are identified and addressed before they get out of hand. Acknowledge good performance. Communicate clearly where shortcomings reveal themselves. Here, I want to give example that through criminal division, from day one, I communicated my expectations to DPP, prisons, assessors, and staff. 3, be in charge of your court, which is under consistency. My lords, a consistent leader instills discipline in their courtroom. If your staff, advocates, and litigants observe your consistency, whether it's in regard to hearing matters on set dates, adhere to the set timelines to deliver judgments, they will follow the suit. For example, avoid unnecessary adjournments, avoid mention of cases when they are ready for hearing, enforce scheduling discipline, agree with the state during scheduling the number of witnesses, remain focused and calm in your court, avoid pressure from defense. For example, in my case, I had a case where I was trying to say we hear this case within 1 week. The defense wanted one month. The prosecution wanted 1 month. I just said no, inquiries are complete. What I can do is let us operate within 3 weeks. So to avoid those unnecessary adjournments, be in charge of your court. Another point is interpersonal skills. A leader should interact and build relationships with others effectively to foster positive working environment. As a leader, you should practice active listening, express thoughts clearly, manage disagreement effectively, work well with others. We should know that we can work with anybody. We prepare our mind that wherever you are as a leader, you can work with any person because we are all different. More importantly, recognize individuals. We are born with potentials. Leaders are not born, but they are made. So let us recognize individuals' potentials, promote teamwork. In civil division, just second introduced the culture of celebrating birthdays for each staff and introduced giving awards for the best performing clerk and those who manage time management. And this, equally, I found it in a criminal division under the leadership of Justice Matovu. If they say Matovu has annoyed you, everybody will know that you are the one who is bad. So, time management. Time management, I want to give example. Still, I had a case where we had agreed that we are meeting at 9. When we agreed to meet at 9, the accused persons were in Ruzira. I waited for the accused persons to come from 9 to 9:30. Then a colleague, a judge, called me that, "Judge, you on social media. The lawyers are just saying that the judge is in chambers, doing his own things. He fixed this matter at 9, and yet it is 9:30, the MPs are here." Now, from that time I said, if I fix a matter at 9, whether the accused persons are not yet in court, I have to go to court, and it's the prosecution tell me that the accused persons are not here, and we agree as a team to wait. I thank you so much, Michael. Thank you.
Let's give him a round of applause. Thank you very much, Justice Baguma. Our next presenter will be Honorable Lady Justice Comfort Kania. On how do we exercise judicial authority, particularly in high pressure court environments. But my lord, before you come on, allow me recognize somebody who gave you that name, retired Justice Kania. I've seen him in the house, so welcome, welcome. And of course, I will also recognize your neighbor, retired Justice Mulangira, and your neighbor also, Honorable Justice Asaf Ntenje Ruhinda. Welcome, welcome. My lord, you may take it away.
Thank you, Chair. My lord, the CJ, my lord, the PJ, your lordships. Oftentimes, the work of a judge entails operating in a high-pressured court environment. This pressure is a result of the potential impact of the decisions that judges can make. The impact of those decisions on the lives of litigants can be very unsettling, so the stakes are high. Sometimes this pressure arises from the nature of the case, the types of litigants. Some litigants are very, what word can I use? They are very emotional by nature. They have a large following and they'll go to all lengths and use all resources available to them to put their matter across to the public. Pressure can also come from an ever-increasing caseload and lately social media, just to mention but a few. So judges are required to exercise leadership in ensuring that they exercise their judicial authority in a manner that manages that pressure that is attached to their adjudicative role. Exercising judicial authority in the face of high pressure court environments requires a combination of strict procedural control, emotional intelligence, meticulous preparation, and an unshakable commitment to impartiality. Judges must manage both the immediate courtroom dynamics and external pressures. The public and media, the courts of public opinion must all be taken into account, while at the same time ensuring that you arrive at a fair trial. I propose certain strategies for the exercise of judicial authority under high-pressure court environments, including the following: strategic case management. The previous speakers have already talked about leadership and its impact on managing cases. Pressure in the courtroom usually builds up even before the judge enters the courtroom. Strategic case management and preparation is key in managing this pressure. The second strategy is to maintain courtroom control and decorum. The previous speaker has already spoken about leadership, setting clear expectations and establishing firm ground rules early regarding discipline, decorum, and in high-profile cases, the conduct of the media. Unfortunately, we can only control the conduct of the conventional media. Social media is a wildfire. Everybody with a phone, with a smartphone, is a journalist, a communication expert, and in some sad cases, an analyst on the merits of the case. So all those things weigh highly on a judge and exert pressure in the courtroom. As part of maintaining courtroom control, we need to manage interactions directly. Do not allow attorneys or litigants to shout over each other. Cross-examination should not degenerate into a shouting match between witnesses and counsel. Sometimes when you recognize that the situation is becoming volatile, you could use a tool, a procedural tool, to take a short break, a strategic short break. Definitely by the time court reconvenes, pressures will have cooled, and so will have the temperature in the room. You leverage security and staff. Court orderlies come in handy. My brother faced a situation where a relative of a litigant almost pounced on him had it not been for the timely intervention of the court orderlies. You may not need to wait for it to get there. You can come up with a code word to let the orderlies alert, to let the orderlies be alert that a situation is degenerating into anarchy. Another strategy is to maintain impartiality and decorum, act with propriety, even when faced with immense pressure, maintain decency, politeness, and good manners at all times. Remaining calm and in control of one's emotions is always useful. There is nothing as unfortunate as being captured in a exchange of hot, bitter words with people in the courtroom. Guard against bias, especially in a high-pressured environment. Bias might be actual or perceived, so guard against the impression that there is bias. Control body language. The camera captures everything, and all communication is not in the said words. Expressions and body language communicate as strongly or even stronger than words. Take into account the different backgrounds and profiles of the different stakeholders in the court. Lead with empathy, recognizing the pressures faced by all the stakeholders. The other strategy is emotional, physical, and mental well-being being key in exercising judicial control. Acknowledge and manage stress. When you're feeling stressed, do not seek to be the superwoman or the superman. Recognize that you're human and that when there is stress, you take time off. Recognize that the work is inherently stressful, and what you can do is to utilize strategies to manage that stress, not to bottle it up. You may end up bursting. You may utilize peer connections for support and to discuss complex high pressure cases. These networks are key in helping you manage the pressures and the expectations that come with it. You prepare physically, ensure physical well-being. If you're sick, you're stressed, you're not going to be able to remain calm and maintain mental clarity during long or intense trials. Effective communication is another one. It has already been mentioned. Be clear and decisive. Make rulings clear, firm, and based on the record. Providing written rulings helps, especially in high-profile cases and for significant matters. It can help manage public perception and ensure accuracy. Listen actively, allow parties to feel heard within reasonable limits. It can help manage public perception and ensure accuracy. In the recent past, judges have borne the brunt of social media attacks resulting from matters before them. I remember a judge in Masaka made a bail ruling, and the next day on TikTok, I saw pictures of his family, his son, I think himself and his wife, with captions, "Tumanyije babera tulumbe." Like, we know where they stay, let us attack. I imagined what that judge might have gone through. You may think that to be fearful was a sign of cowardice, but cowards live longer, and you do not know what such a message can do to a mind that is already unhinged. So the pressure can be real. My brother here has also tasted the hot soup of social media attacks. I will not hesitate to say that I have also tasted that hot soup, and I can assure you that the pressure it exerts, it's immense. How did I survive it? Peer support, the head of the division, some members of the bar, Surprisingly, that is the collaboration and teamwork I'm talking about. Those words of comfort are very helpful. Affected judges should also seek the services of counseling if the pressure gets so high. I have just learned that from Dr. Bijirimana that we have counseling services. Thank you, PS. I conclude with a quote made at the first International Day for Judicial Wellbeing, that was 25th July 2025, by Judge Jose Igrea Metos, member of the Advisory Board of the Global Judicial Integrity Network and president of the Court of Appeal in Porto, Portugal. He stated that judges around the world face immense stress, high workloads, and unprecedented pressures. These factors compromise their mental health, leading to burnout, reduced productivity, and ultimately impairing their ability to deliver justice in an impartial manner. We must confront these challenges head on. Fortunately, the judiciary leadership is here. I close that. Thank you.
Thank you very much. Let's appreciate Jaskania. Thank you very much. I strayed into an area which wasn't mine, but since I started it, let me conclude. We have with us Chief Justice Emeritus Jasowinyi Dolo. Thank you very much for coming. We have DCJ Emeritus Just Stephen Kavuma. Thank you very much for coming. And next to Jaskania on one side, I introduced only one side, we have retired Justice Flavia Anglin. And next is retired Lordship Lady Justice Maitum. Thank you very much for coming. Now we are going to open it up, and the topic, in case you took long checking out and were not here at the beginning, our topic is judicial leadership and its impact on effective case management. I'm listed as a panelist also, but in the interest of natural justice, I can't be a chair and a panelist, so I'm opening it up to the plenary. We have a few minutes to go, about 10. If you have any contribution, any question, this is the time. I will take the first 3 people, and then we'll come back for the panelists to conclude. Any contributions? Any questions? Yes, there's one there. Are there others so that I pick once for all? Okay, let's start with you. That must be Lordship Henry Issa Kawesa.
Areas which I wanted to highlight is about how a leader should respond to complaints that are received about the people they lead, especially in this world of today. Not everything is now on social media. Not everything is on social media. There are those complainants now who have made it a habit. Once they lose a matter, the next thing is to write a stinker and say the fellow is taking bribes everywhere, is writing substandard rulings and all these abusive things, and then they send, copied it to Judicial Service Commission, copied it to the president. So as a leader, sometimes you read those things and you know this is obviously untrue. But do we still need to ask that person to answer, show cause, and then it goes on the private file? That is for me to learn. How do we handle such uncalled for complaints but are put in writing and forwarded to a number of institutions? You as a leader, how do you help that person?
Thank you very much, Your Lordship, for that question, how to handle complaints. Of course, we can expand it to against yourself and against others that you lead. Any other question? There being no other question, I'm going to ask the panelists to go at that question and also you make your concluding remarks. Let's start with just Sarah Langa.
Thank you, my lord. I'll make it as a former administrator who was receiving quite a number of those complaints. I think ordinarily it would be good to have a response because it clears the matter at the end of the day, because when it remains hanging or unresponded to, times could change and people could sometimes think that is the truth of the matter. So in my view, it would be okay for a complaint that has been received to be responded to, even if it may not have merit, because it is the response that will clear the fact that it has no merit. But I'm glad we have the Deputy Chair, JC, here, who will be able to give a better response to that. My lord, my parting shots from my part was just to emphasize the issue of mentorship, that let's aim to have one brand, especially at our different levels. Right now, we are trying to develop a Wakiso brand, and we are calling ourselves the Wakisonians. And we are saying, what should a Wakisonian do and not do? We want a uniform standard so that when you go to our court in Sanji, you find the same standard. When you come to the High Court, you find the same. We want best practices that move among all our people. And I think if we all developed brands, would have only 29 High Court brands and 7 division brands, and at the end of the day, would have the entire judiciary there. And what do I emphasize here is the need to bridge the gap between the upper bench and the lower bench, and to be able to bring on board the young people who are on their journey upstairs. So together we move, together we can, and together we can make judicial leadership very interesting, and at the end of the day, be able to deliver on our core mandate very, very well. Thank you, my lord.
Thank you very much, Justice Langa. Just Baguma, how to handle complaints, and then you can make your concluding remarks.
Thank you, my Lord Chair. When I was the resident judge in Mpigi, is a lawyer who made a complaint that a grade 1 had received money. I said, put it in writing. I don't want this here say, put it in writing. He said, let me go and put it in writing. He didn't come back. He disappeared. Then, in a civil division, I was the deputy head and I agreed with the head Justice Sekana, the same approach. When people come and say there is this, we agreed, let people put those things in writing, and then you are able to, based on something, to ask a person whether this is true or not. To avoid some people blackmailing and spoiling people's names, me as a person, I normally ask where I am as a leader, that reduce your complaint. Now, if they reduce the complaint in writing, then I call the person, what do you have to say about this? And then the person responds, and I'm able to take action. Finally, as a leader, it's better to have open door policy, do consultation with others if you are 2 judges at the division, harmonize and streamline the system, consult each other, and all in all, humility is very important. Thank you.
Thank you very much, Judge Baguma. Now we go to Justice Kania on complaint handling, and then your final remarks.
Thank you, my lord. Every complaint received must be looked into, because until you look into it, you cannot determine whether it is frivolous or whether there is some meat to the complaint. The criminal division, I have received complaints in the past about some members of my staff collecting money from litigants for cause listing. I asked the person who was complaining to come and ask them what evidence they had. There was evidence of mobile money transactions between that member of the staff and the person who complained. I asked them to pay the money and forwarded the matter to the deputy registrar. I did not follow up on how it ended. From the perspective of the Judicial Service Commission, every complaint received is processed. It is logged, given a number, the complainant is written to and asked to come for an interface with the commission and provide further information. Upon the further information they've provided, an evaluation is conducted. Following that evaluation, the decision is made or as to whether the complaint has not disclosed any wrongdoing, and the complaint will be closed. A letter will be written to the person against whom the complaint was levied and also to the complainant. Where there is some meat in the complaint, the person complained against, in this case, we refer to them as the respondent, will be invited to give their side of the story, and the complaint will be processed. If we find that there is wrongdoing, a decision will be made by the disciplinary committee, and the matter will be forwarded to the full commission for decision. Thank you. Oh, sorry, I'd forgotten the parting shot.
Yes,
sorry,
please go ahead.
Chairman. My parting shot is that the importance of managing pressure in adjudication cannot be overemphasized. Pressure which is unmanaged can not only compromise the health of the judge, but also compromise the quality of judgments. Therefore, strategies to manage pressure must be adopted and applied in the day-to-day adjudication. Thank you.
Thank you very much. Let's give her a hand clap for that elaborate. So just
excuse me, on the issue of someone giving an officer money to cause list his or her case, is the giver punished? Because it's two-way. There is the giver and the receiver. Or do you take action only on your officer and you ignore the person who gave?
have you directed that to a particular panelist?
To you.
Thank you very much. The Vice Chair of the Judicial Service Commission is here, and I want her to give us the practical steps that are taken by the Commission. Then I'll come in. Yes.
I don't think the commission punishes the giver. It only punishes the receiver. And when I had that problem in my court, what I did was that when the person who took the money paid it back to the giver, I forwarded the matter to the deputy registrar. I did not follow up from there to see what happened.
Okay, I will give.
Yes. IGG.
Yeah, for my IGG emeritus. Okay.
Okay, thank you very much for the presentations. Leadership in adjudication is very important, because unless we are all leaders, we will not be successful in adjudication. Now, the giving of incentives to fix cases is a very common practice in the courts. It's just that in most cases it is not. Actually, it is never reported. But those of us who were, I was an advocate for 19 years, and I know that it happens. People give money to clerks to facilitate the fixing of cases. Now, about the giver and the receiver of such money, the person who gives money and comes and says, I gave money to so and so, becomes an ally. And when they actually stand up and give you the details from their telephone, they have become a witness. They are doing it to help you. And ordinarily in corruption, anti-corruption speak, they would become your allies, and sometimes there's even an incentive when you recover the proceeds of the bribe. According to the IG Act, there's a certain percentage that is given, and that person becomes a witness. Now, do you punish your witness? Justice Gash, would you punish your witness? To punish a witness.
My Lord Chair.
Then they would become hostile.
Please,
let it become a battle.
Justice Gash, please.
I shouldn't punish.
Please keep your peace. Just Muliagonja, could you summarize, please?
Yeah, I have finished.
Thank you very much.
They become your witness. They
Thank
have
you.
come, they have cooperated with you, they've told you there's a problem in your court. I gave money to so and so, and I am willing to testify against that person. This is the evidence. Why would you punish them?
Thank you. Thank you very much, my lords, worships, ladies and gentlemen. Thank you for being such a good audience. Could you please give a hand clap to the panelists? And if you have some extra energy, you can give a hand clap to the chair as well. And I will ask the panelists and myself to leave as I hand over to the principal judge to lead us to the next session, which is the resolutions that we are going to adopt from this conference. My Lord, the PJ, over to you.
Thank you so much, Justice Mike. And we are coming to the end. Let's have who are the, please project the resolutions. We can correct as we go along. I think as we wait for the technical team, I can see they're working. We could get up just for wellness. And as we get up, let's write the word, which one? Wellness, using our words, please, without being obscene. Wellness. Okay, I'm told the wellness team is here, but be writing wellness, please, without being obscene. Yeah.
Good afternoon, my lords. We are back. Remember? Remember us? Yeah. Say brrr. Brrr. All right. We are going to start today with my colleague Andrew. I did my session yesterday. Let's see what Andrew has for us today. Thank you.
Yeah, so we're gonna do just up. You're gonna take your right arm over your left. Right over left. Oh, left, hold your nose. Then the right, here.
Some people have two left hands.
Digital, analog. Digital to analog. Digital, analog. So let's Some people are like this. Okay, so we're gonna take our body a little bit. We're gonna just count from 10 until we reach 1. We can just count 1, 2, 3, up to 10. Even this side up to 10. We kick up to 10, then we go to 9 until we reach 1. Are we ready? Okay, start. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Come on.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8.
8.
1, 2, 3, 4, 5, 6, 7, 8.
8.
1, 2, 3, 4, 5, 6, 7, 8. 1, 2, 3, 4, 5, 6, 7, 8.
7.
1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7.
Almost there.
1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6.
Come on.
1, 2, 3, 4, 5, 6.
Uh-huh.
1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Uh-huh. Uh-huh. Uh-huh.
Huh. Uh-huh.
Thank you so much. I think now we are ready for our session.
Are we?
Yes.
All right. We'll be coming back later. Thank you. Thank you.
Thank you so much.
Thank you.
Okay, now let's settle down.
My Lord Chief Justice, my Lord Principal Judge, my Lords Judges and Your Worship's Magistrates, good afternoon. These are resolutions or recommendations that came from the discussions that we've had since Monday, and they are being presented to you for approval or otherwise. On institutional and policy reforms, the first is that we enact a comprehensive judicial wellness policy, develop and implement a formal judicial wellness policy that mandates supportive structures, including mandatory restorative leave and nationwide destigmatized confidential psychosocial support services accessible to all judicial officers and staff.
Can we take that one or we want to modify it? Has it been captured? I think we can go to the next one. I don't see an.
Include the Judicial Wellness Day on the JTI calendar.
Bring it down.
My lords, there is a bit of, so a document was worked on and unsaved, so there's a bit of difference, slight difference, and maybe the person projecting should come for the amendment document.
So you're reading which one? 1.2.
1.2. Unfortunately, it's not
human resource.
So that is our 1.3, strengthen human resource and administrative frameworks, expedite the development and adoption of a comprehensive judiciary human resource manual, covering transparent policies for transfers, promotions, discipline, and welfare.
Was that captured well, or do we? Okay. I don't see.
Operational and case management improvements, institutionalize plea bargaining as a daily court activity, issue a practice direction to integrate plea bargaining into daily cause lists, moving beyond periodic camps.
You have not finished reading.
Should I finish all the three in under there?
No, no, no. The sentence, this will prevent coercion from prolonged demand and enhance efficiency.
With your permission, my Lord Chief Justice, I request Tony, please come forward and pick this. My Lord, when we discussed that as the team working on the recommendation, we thought it was that part was not properly coming out, so we had omitted it. But the House can discuss it.
Is it captured well,
No,
or
no,
should
no, no.
we? Yes, my Lord Justice Matubu.
My Lord PJ, I don't think we should move away from beyond periodic camps. It should be in addition to periodic camps. Yes, in addition to periodic camps. That word moving beyond is not good. In addition to periodic camps. Actually, the camps are more important than the daily hearings, according to me. Because the daily hearings is one person saying, I want to plead guilty. But the camps, we go there and do a lot of work. They should move together.
Yes, and then the word, this will prevent coercion. I don't understand what that means. We could just say this will prevent situations of prolonged remand and enhance efficiency.
I think what they want to bring out is that so that we cut out those people who join plea bargain because they have stayed long in prison. I think that's what
We
you were trying
understand
to
that.
capture.
I agree, but why use the word coercion? Who is coercing who?
Exactly. Or we just do away with that second part.
Maybe. Yes.
Okay.
Just do away.
Let's remove the second part. This will prevent, we just leave it. I think we need to have the corrections done immediately. Someone can be typing. Okay. Delete the last one.
It's already. Thank you. Standardized sentencing guidelines for common offenses under plea bargains should be developed to reduce disparity and promote uniformity.
Yes, please. Yes, my Lord Justice William Gonja.
Thank you, my Lord PJ. That proposal, or rather the resolution to standardize sentencing guidelines for common offenses, I think that there's already a move to improve or amend or whatever it is to review the sentencing guidelines. Why should we do it piecemeal for specific offenses? Shouldn't we do the whole document and review it?
Well, my Lord, I think there was a proposal at some stage that we needed to look at the pre-bargaining separate from the trial. Although that may not necessarily be a good option, we can combine them. You can get, for example, a specific offense, then go into the normal trial and then go into pre-bargaining, so that we have one document. That is a more plausible option. But I think this is just emphasizing the aspect of pre-bargaining. But in practice, we shall have a combined document.
Okay, the next one, so we keep 2.2. 2.3.
2.3, mandate proactive judicial referral to ADR. Empower and require judges through a practice direction to conduct early case assessment and actively refer suitable matters to mediation, especially at the scheduling stage. This should be supported by mediation orientation.
Can we have the
political.
cursor moving up? You can't control it there. Okay. Yes, 2.3. Yes, Justice Bazasa.
My lord, that 2.3, isn't it covered under the new draft rules, mediation rules 2025? I think it's totally covered under there. And Justice Kauka, you want to comment about that?
My Lord CJ, you recall you chaired the Judicial Law Reform Committee and eventually went to the Rules Committee. These rules were approved. They are before the Attorney General. And I think we are hoping that mid this month, the Attorney General will be forwarding them back to you for signature and then subsequent publication. But as the Lady Justice is saying, they are detailed, they cover those aspects as well. Thank you.
So what are we saying? Should we delete it?
I think so. Because it's very comprehensive. 2.3 is well covered under those rules.
The thinking here is that why can't it just stay there since it's just a resolution? Because we never know when the rules will come. For the time being, yes, my lord. Use who is the neighbor? Yes.
Yes, I apologize. Now, when we make these resolutions, and I want to point it out at this point in time, we make so many resolutions here. We come back next year. This year, we have not looked at the resolutions we made last year. Do we know how many we implemented? We don't. So we are putting them all here. But what is this one going to do to help us when there's a whole process for ADR regulations and so on? What will this one do to change the other one that is in progress?
Okay, so do we agree that we remove, yes, Justice Jean?
My Lord PJ, I think I agree with you. If we maintain the resolution now, then next year when we're discussing this resolution, if the practice directions are in place, then that will be a deliverable in as far as this is concerned.
Okay, yes, any other intervention? I think we shall go with the last one. We keep it there. We shall have ticked the box next year. Yes, 2.4.
Thank you, my lords. Implement a rigorous performance tracking. Leverage the 2025 National Case Census data and ICMIS to track individual and court performance on backlog clearance, ADR referrals, and case aging. Use this data for resource allocation and targeted interventions, not for punitive measures.
Yes, any intervention on that one? Okay, so we are keeping that one, 2.5. No, you're going to the next one.
We're going to 3, capacity building and culture shifts. Launch a comprehensive ADR and Africanized justice training program. JTI, in collaboration with the Law Development Center and universities, should 1, integrate restorative justice and ADR practice deeply into the legal education curriculum. Conduct mandatory continuous training for judges on ADR referral skills, plea bargaining procedures, and wellness self-management. Extend training to registry and support staff on ADR processes and timeline management. Offer subsidized high-quality ADR certification for private lawyers to build critical mass of practitioners.
They will just intervene when.
4, foster leadership, accountability, and collegiality. Fund.
Microphone manager.
I will become the manager.
I appoint Justice Obura to manage your microphone.
Can you please,
Be
go
close
back?
to her when she's going to speak.
I'm sorry, can
I
you please
gladly
go back
take that
to,
appointment, my lord.
to 3? When you look at 3.1, what role do we have in forming the legal education curriculum before we now start making a resolution like that one?
I think, my lord, what is coming out is that we need to engage these institutions, especially the JTI. The JTI is supposed to collaborate with institutions, and this is one of the points of engagement, where for example, especially LDC. I think LDC is already kind of on board on this, but then we need to engage universities. As you noticed yesterday, we talked of universities already which are on board, and they were talking of other universities to include into the conversation. So the resolution specifically means that we must engage.
Engage, not integrate. Because it's already integrated.
Yes.
It's already integrated.
Let's engage.
The new legal education curriculum has ADR at university level and at LDC level. So now what are we going to integrate?
No, it's only at LDC where I know we offer, where we have engaged fully and they have embraced this, but some universities have not. So perhaps we need to get a better word. We rephrase. Do we say engage or do we say integrate, or whichever? But we can redraft, I think, according to what we are going to just propose.
Engage. I think my
Collaborate.
Lord CJ, I think from your explanation, I think we have to rephrase it to read what Justice Muliagonja said, that we engage.
Can you rephrase? Can you rephrase it?
Thank you. I would say engage with the legal education institutions to include restorative justice and ADR practice in the curriculum. Actually, not to include, to implement, because the new curriculum is there. And the new curriculum, we ensured that we put ADR and restorative justice.
Thank you so much. Thank you, my lord.
My lord chair, I beg her pardon. I beg your pardon, my lord, on the rephrased sentence.
I think she said engage.
Engage with the legal education institutions to implement.
To implement, we are in 3.1, eh?
Yes, my lord.
Engage the
legal education institutions.
Implement the
To
policy
Okay.
of training students in ADR and the restorative justice, because it's there in the curriculum.
Thank you so much. Thank you, my lord. So you go now to 3.4. Oh, you had already done that. 3.4. 3.4.
That's fund and promote structured team building and collegiality activities to break down hierarchical barriers and improve institutional health. Resource allocation and infrastructure, prioritize budgetary support for key initiatives, adequately remunerate quota-next mediators to attract and retain experienced professionals, allocate specific funding for the operationalization of the Attorney General's ADR department.
I think you delete that. We can't finance another institution. It's not possible. We can only maybe engage them to with their department.
Yes,
we can have an engagement, but not funding them.
Yes, my lord, Chief Justice. That's why it's in a separate color. It was not for the judiciary to fund, but for judiciary to engage with the Attorney General's office to ensure that they fund the ADR unit in there.
You delete it so that we
Okay.
are not confused.
Okay. Thank you. Allocate specific funding to the JTI for the rollout of the national ADR policy.
Yeah.
Budget and provide sufficient resourcing to the Uganda Legal Information Institute to support the update of legal libraries. It was supposed to have online legal libraries, and I seek your permission to include the word online.
Yes.
Thank you. Support the construction of institutional housing for judicial officers, especially in remote and hard-to-reach areas, to ensure security and retention. Number 6, ADR dispensation of justice for all. Formalize ADR integration through law and rules. Domesticate the Singapore Convention on Mediation to facilitate enforcement of international mediation settlements. Fast-track the issuance of the proposed new court-annexed mediation rules by the Minister of Justice and the Judiciary. Consider legislative amendments to make pre-litigation ADR attempts mandatory for certain civil case categories, following models like Tanzania's.
Yes.
PJ, there's a hand up here.
Yes. Justice was
6.1.1. Do we have the power to domesticate a convention, international convention? That's for the Foreign Affairs and the Attorney General's chambers, I think. That 6.1.1, I think, is not for us.
So we can use maybe the word engage. Apparently, Uganda is signatory to this convention, but what we have not done is to domesticate it. And domesticating it would help, especially private mediators, to be able to function properly. So I think we can maybe say engage either the Attorney General's chambers or Minister of Justice to see whether they can domesticate.
Thank you. Thank you, my lord. CJ, yes, we can go ahead. AI.
My Lord PJ, can
Sorry.
we improve on the drafting of 6.1.3? Instead of saying following models like Tanzania's, can we say following Tanzanian model? Maybe.
Thank you, my lord. Thank you. Your boss.
Yes, my lord.
The next AI.
AI, use of AI tools for automated transcription to convert spoken words into judicial proceedings. To convert spoken words in judicial proceedings into text in real time to improve transparency and accessibility. Ethical and responsible use of AI by judicial officers in judgment writing and reasoning. This includes verifying all AI outputs, doctrines, case law, and arguments for accuracy. Deployment of AI for case and caseload management to route petitions to appropriate judicial officers, docket control, or panels.
Okay. Yes, we can. Yes, we can go.
That is all, Madam Chair.
Okay. Thank you so much. That's the end. That is the end of the resolutions. Please, let's give a hand to our worship Lillian Bushana. Thank you so much. Thank you. So shall we get the corrected version?
Yes, we will work on the corrected version, my Lord Chair.
Yes, but I think going forward, we should be able to first read the last ones, the last resolutions and what we have covered, and then so that we carry forward. If we have not done everything in the year end, we carry forward to the next year.
Okay.
I think that would be better better way to do it.
We've
But
taken
thank
the
you so
guidance.
much. Thank you so much.
Thank
I
you,
now
Chair.
want to hand this back to
And I think the question Justice Mudiagonja raised about implementation. You see, we are going to unpack this, and in our, I think we already have a plan to have a retreat and stop management, and we shall unpack these resolutions, and we see how we implement them going forward. Because we can't continue making the resolutions and then they remain on the paper. And that's why our delivery unit is going to be critical for this. So when we unpack them, then we shall attach them to that delivery unit. So that every month we review what have we achieved, what have we failed to achieve, why have we failed to achieve it. So this is one of the things we shall look at, the resolutions.
My Lord Justice, we are just changing seating arrangements. I will request the Chair Governing Council to come and also sit aside so that we proceed into the closing ceremony. With your permission, our guest of honor and Chief Justice, let me request that we all rise for the national anthems. Thank you so much. We may take our seats. My Lord and our guest of honor, allow me invite the Chief Registrar. to take us through the program and this ceremony. Your Worship.
Thank you very much, PRO. My Lord, the Honorable the Chief Justice. My Lord, the Honorable the Chief Justice Emeritus. My Lord, the Honorable the Deputy Chief Justice Emeritus. The Honorable Minister of Justice and Constitutional Affairs. My Lord, the Honorable the Principal Judge. Chair, Governing Council, Judicial Training Institute. My Lords, the Justices and Judges of the Courts of Judicature. Serving and retired. The Executive Director, Judicial Training Institute. The Permanent Secretary, Secretary to the Judiciary. Your Worships, the Registrars, members of the Judiciary Senior Management, and heads of departments and units, Judiciary. Your Worships, the Magistrates present, esteemed staff of the Judiciary, especially staff of the Judicial Training Institute, the Fourth Estate, ladies and gentlemen, a very good afternoon to you all, and I welcome you to the closing ceremony of this three-day Judges Conference convened under the timely and thought-provoking theme of Judicial Wellness, a tool for effective case management. Honorable Minister, over the past 3 days, this conference provided us with a rare and valuable space to reflect and engage candidly on the human dimension of dispensing justice. We also discussed other matters pertinent to the administration of justice. And within this period, we have been reminded that the judicial efficiency and quality are not sustained by systems alone, but by the well-being, clarity of mind, and resilience of those entrusted with the solemn duty of dispensing justice. The conversations we have shared have underscored an important truth, that judicial wellness is not a personal luxury, but an institutional necessity. We agreed, Honorable Minister, that a healthy, supported judicial officer is better equipped to manage cases effectively, to deliver timely decisions, and uphold the high standards of integrity and professionalism expected of the bench. We are therefore honored to have you, Honorable Minister, to bring to a close this important conversation and the conference. Your presence with us is a continued testament of your support for the administration of justice and for the initiatives that strengthen judicial effectiveness, that including the well-being of judicial officers, and not to mention, Honorable Minister, your continued goodwill towards the judiciary. Honorable Minister, my name is Lamunu Pamela Ochaya. I am the Acting Chief Registrar of the Judiciary, and I am the Program Manager for this closing ceremony and the entire conference. We have a brief program for this closing ceremony, and we shall have remarks by the Executive Director of the Judicial Training Institute. We shall have remarks by the Chairperson, Governing Council, JTI. We then shall hear from the Honorable the Chief Justice, and Honorable Minister, we shall hear from you in your address to us as you bring this conference to a close. We shall have anthems, and time allowing, we shall have photo session, and we will depart after we have had lunch. This is our brief program. I will be supported by the Registrar Public Relations and Communication Judiciary, His Worship James Jumire Mawanda. Honorable Minister, allow me to make quick introductions of some dignitaries who are in this room with you. And on your left, Honorable Minister, we have the Honorable the Chief Justice. Honorable Dr. Flavian Zasia. We also have present with us your brother and His Lordship, Chief Justice Emeritus, Honorable Alphonse Chigamoy Owindolo. Also present with us, we have Deputy Chief Justice Emeritus, Honorable Stephen Kavuma, my Lord. We have the Principal Judge who has just walked out, but I believe she'll be coming back. In her absence, allow me to introduce to you the Chair, Governing Council, Judicial Training Institute, Honorable Justice Mike Chibita. We have with us Honorable Minister, we have the Justices of the Court of Appeal present with us. We have the Judges of the High Court present with us, Honorable Minister. And we have the Executive Director, Judicial Training Institute present with us. We also have the registrars present with us, Honorable Minister, and staff of the judiciary. We have, I beg your pardon, the Permanent Secretary, my twin, the Permanent Secretary to the Judiciary, Dr. Pius Bigirimana, present with us. Honorable Minister, at this point, allow me now to invite the Executive Director, Judicial Training Institute, to make his remarks. He will then invite Chairperson, Governing Council, Judiciary Training Institute, to also make his remarks. Thank you.
Thank you, my sister, the Chief Registrar. My Lord CJ, kindly allow me stand on the protocol laid by my sister, the CR. My Lord CJ, mine is appreciation to you for the guidance that you offered us in the way we framed this conference. I remember when you called me to your chambers to have a conversation on how this conference should be framed. You wanted 100% participation of the judges in organizing their conference. And you tasked the principal judge to coordinate with the judges in organizing their conference. And my Lord, we want to really thank you. As the researchers, we have done a bit of research for the last few days we've been here. And we want to report to you that participation of the judges in organizing and running their conference is at more than 95%. My Lord CJ, we also want to take this opportunity to thank the Permanent Secretary of the Judiciary. We were having a side conversation with him, and if you may realize, this time round, his participation is at 100%. Yes, we want to thank you. My Lord, the Chief Registrar, my sister, we want to thank you so much for being able to coordinate the efforts that have been able to enable us achieve. My Lord CJ, the Chair Governing Council, who gives strategic direction to the JTI, the Honorable Justice Mike Chibita, and members of Council, informed the concept note on judicial wellness. And my Lord, at this point, allow me to thank you again. I will say a bit of what I said at the opening of the conference. When we were with you in Banjul, after the presentation on judicial wellness, you walked to me
and told me this is something we should do. But Ujoa, Lady Justice Kazare, if you could stand up for recognition. Lady Justice Olive. My Lord CJ, Lady Justice Olive had organized the Ujoa membership and done a wellness thing. And I recall, I think, Chair Governing Council, you represented the Chief Justice at that Ujoa wellness thing, and that laid the foundation for us to have this theme. My Lord CJ, you realize on the program, we had session chairs who moderated these panel conversations. We also had panelists who gave it all their best. I request that we clap for them and appreciate them. The JTI team, there has been a lot of pressure, positive pressure, my Lord CJ, running up and down. Lillian and the JTI team, if you don't mind, you do stand up for recognition so that the CJ will lead the clapping for you people who have been able to put this together. Honorable Minister, allow me to appreciate you in a very special way. My Lord CJ, while you were principal judge, you will remember you and the Honorable Minister and CJ Emeritus led the efforts of developing the Judiciary Alternative Justice System Strategy. You also led the efforts of developing the National ADR Policy. And at this point, I would request my Lord CJ for us to appreciate the Honorable Justice Richard Butera, who chaired the meetings on the request of the CJ Emeritus. And these two meetings informed the development of the Judiciary Alternative Justice System Strategy and the National ADR Policy. My Lord CJ Emeritus, if you don't mind, allow us to appreciate you. My Lord CJ Emeritus and CJ Emeritus. Honorable Ministers, you come to speak. You will remember the meetings we had in your office. Several meetings, up to late hours of the night, working on the National ADR Policy under the guidance of CJ Emeritus, DCJ, and PJ. And I would request you also to share the famous story of Tom Sawyer with those that have not heard it. With those few remarks, I now invite Chair Governing Council to come and make his remarks. Thank you.
Thank you very much, Executive Director. My Lord Chief Justice, I will adopt the protocol. But before I start my remarks, which are very brief, there is something which I started, and let me end it. I introduced retired judges, and because I was not putting on my glasses, I missed out Lady Justice Margaret Oumo Oguli, who is with us. Please appreciate her. First, I must thank Honorable Chief Justice for your strong personal guidance in this conference. From a theme properly chosen, the method and mode of presentations, and your presence throughout the conference. Let's appreciate Chief Justice. Your leadership has been instrumental in guiding the Institute from operationalizing the Governing Council, direction in stopping ad hoc trainings, and approval of the JTI training calendar, which has been effected with the preparation of this conference. We commit, as the Council and Management of JTI, to do whatever it takes to build an institute into a true center of excellence, one that is fully aligned with the strategic priorities for the judiciary so as to clearly articulate our vision. The depth of our discussions over these days has been remarkable. We have confronted the real pressures of judicial life, long hours, heavy caseloads, emotional toll that it takes, and we have collectively explored practical, human-centered solutions and even listened to real-life experiences. From leveraging artificial intelligence to adopting restorative justice through ADR, promoting leadership that supports wellness, ensuring consistency in our judgments, we have reaffirmed a fundamental truth. A well judge is an effective judge, and a supported judiciary is a bedrock of public trust. The presentations we have had, born from your own experiences and prepared in your working groups, have provided a very powerful, authentic foundation for our resolutions, and I'm confident that insights and commitments captured here will not remain within these walls, but will be translated into action across our courts. And on that note, I would like to extend my sincere gratitude to each of you and to the panelists for a job well done. Let's give ourselves a hand clap. Let me again thank our keynote speaker, Honorable Justice Dr. Mumba Malila of Zambia, and our distinguished guests from Kenya, Justice Isaac Lenawola and Justice Smoking Wanjala, and all the panelists, facilitators, and participants for your invaluable contributions. My appreciation also extends to the entire JTI Secretariat under the able leadership of the Executive Director, Honorable Professor Justice Andrew Hauha. Let's give him and his team a hand clap. We also thank our partners for the flawless execution of this conference, and I also extend my gratitude to our development partners for their unwavering support. We've got some feedback, and the feedback we've got is that you have liked the setting and the way the conference has been set up. There is, it's not an opinion poll, but feedback mechanism, which has been sent to your forms, and some will be sent out in paper so as to ensure that we get the feedback. Please fill it so that it helps us in our future conferences. In conclusion, as we depart from Munyonyo, we are departing not just well-informed, but very, very well renewed. Let us carry forward the spirit of this conference, a spirit that places the well-being of the judicial officer at the heart of service delivery. By doing so, we honor our oath, we serve our nation, and we move decisively towards our shared vision, justice for all. Thank you very much, and may your journeys back be safe, and may God bless you, and God bless the judiciary of Uganda. And with those few remarks which I've made, I say all that for God and my country. And before I depart, allow me now to invite the Honorable, the Chief Justice, to make his remarks, and thereafter invite our guest, the Minister of Justice, to close officially. Thank you very much. Let's give a hand clap to the Honorable, the Chief Justice.
My Lord, the Honorable, the Chief Justice Emeritus, the Honorable, the Deputy Chief Justice Emeritus, the Honorable Principal Judge, let me stand on the protocol that was earlier on outlined. My Lords, it is my singular honor to address you this afternoon as we conclude the 27th Annual Judges Conference. Allow me from the onset extend my profound appreciation the Chairperson Governing Council JTI, and the Executive Director Judicial Training Institute for organizing a successful 27th Annual Judges Conference. The theme for the conference and the topics that were chosen for discussion were all well thought out, insightful, and relevant to us all. I equally thank the Honorable the Principal Judge for coordinating organization of the conference. From the presentations made, the presenters exhibited appreciation of the subjects of discussion, a sign that they dedicated time and undertook in-depth research that undertook in-depth research. Thank you for the preparations, effort, and input. Effort and input the presenters and discussants put into the presentations. If you notice, we adopted a different model, and this model we adopted is that you team up all levels of court hierarchy and have one presentation on a particular topic, so that the presentation is holistic, encompassing all the experiences. And that model works very well. So we, of course, eventually, these presenters had a paper, but we adopted a question format to abridge the paper. So what will happen eventually is that these papers are going to be uploaded. I will tell you how we shall go about it. This conference has provided each one of us a valuable opportunity to reflect on our wellness vis-a-vis our work. I'm certain that we have all appreciated that our physical, mental, and psychological well-being is very important, and in fact determines our efficiency and effectiveness in whatever we do. The conference has also provided us space for dialogue, sharing experiences, best practices, challenges, and insights that will guide each one of us as we execute our day-to-day roles. I'm confident that we shall all leave this conference venue better equipped than we came. As judges of courts of record, our responsibility goes beyond error correction. We are custodians of precedents, interpreters of the Constitution, and guardians of the rule of law. The decisions we render have far-reaching implications on governance, commerce, and the rights of citizens. Our role is therefore enormous, and we must execute it with measured temperament and utmost sobriety. Our awareness is therefore paramount when we are both inside and outside the courtroom. As we head back to our duty stations, let us remember that judiciaries worldwide are moving towards mechanisms that not only resolve disputes, but also heal relationships, preserve commercial partnerships, and reduce litigation costs. Therefore, alternative dispute resolution in its various forms such as mediation, conciliation, arbitration, and negotiation enhances justice delivery. It complements our judiciary's role by offering litigants a more participatory, cost-effective, and restorative path to resolutions of disputes. We must therefore encourage and support mediation of cases that come before us. Let us also offer leadership in the ADR space. It is then that we shall inspire all other stakeholders to embrace this innovation and resultantly help reduce case backlog. The use of technology in delivering quick and affordable justice cannot be overemphasized. The judiciary embarked on a digital transformation journey to improve efficiency, transparency, and access to justice. We have embraced the electronic court case management information system, virtual hearings, and digital filing, all of which are reshaping how justice is administered. As judges of the courts of record, we must again lead by example in adopting and utilizing these tools. Technology enhances not only the speed of our work, but also integrity of the judicial process through better record management, timely access to case files, and transparent communication with court users. It also simplifies legal research, as you must have witnessed from some of the presentations at this conference. Let us therefore commit ourselves to continuous learning in this area. Technology is not meant to replace judicial wisdom. It is a tool to support it. A modern court of record must be both intellectually and technologically proficient. As you know, technology outpaces legal reform, and you cannot fight technology. You must adapt. We have no choice. So, my lords, I know some of you who are uncomfortable with technology. We have no choice. You can be slow into adoption, but at least you must comply. As we know, this is a season for election petitions. I'm certain that we shall also have appeals arising from them. Let us give them the priority and intention they deserve and dispose them off within the set timelines. If we go by the ones we received before the elections, I think Civil Division had 90, above 90. So that is a pointer to what will happen after the gazetting of the MPs. So we need to prepare for that. My lords, allow me to speak about collegiality, which lies at the heart of appellate adjudication in the Court of Appeal and Supreme Court. The strength of collegial courts lies not on individual brilliance, but in collective wisdom. The judgments we render are a product of consultation, respect, and record consensus. Collegiality requires humility and willingness to listen to one another, to differ without hostility, and to deliberate with mutual respect. It demands that we speak to one another as brothers and sisters, as colleagues united in a shared mission to do justice to the people we serve. When we work together harmoniously, we not only enrich our jurisprudence, but also strengthen the institution's integrity of the judiciary. Let us therefore uphold the virtues of teamwork, respect, and professional courtesy. As senior members of the bench, our conduct sets a tone for the entire judiciary family. This way we shall be promoting judicial wellness for all of us. I direct the director JTI, or maybe directing is not a good phrase. I request the director JTI to extract for me a matrix of resolutions from this conference, and I undertake to write to all action officers for implementation of the recommendations. When we come back next year, we should be able to assess how far we have gone implementing them. I call upon every one of us to implement the recommendations on wellness. The presentations in this conference were 100% judge-led. I thank all your lordships for a job well done. The JTI should publish all presentations in a journal for resource and reference purposes. And I think this is what I was telling you, that the director JTI should coordinate this so that all these presentations, the presenters have full papers. So we shall reduce them into a journal and share it so that then you can read them. I'm assuming you read them. Now, before I conclude, I want to thank the JTI team. The teamwork you exhibited in organizing this conference is unmatched, and I encourage you to keep it up. I know it's not easy to organize a successful conference, but I can, without any fear of contradiction, that this was a successful conference. Thank you for listening to me. With those not few remarks, I take this opportunity to invite the Right Honorable, the Honorable Minister of Justice, the Right Honorable Minister of Justice, to close the conference officially. He's popularly known as TS. I will not tell you the full meaning of TS. Thank you so much.
My Lord the Chief Justice, my Lord the Chief Justice Emeritus, I now see that this retirement is real. There's a sign in front of you reading, former national leader. It has come home now. My Lord, the Deputy Chief Justice Emeritus, and my Lord, the Deputy Chief Justice Emeritus, who is your immediate past predecessor. My Lord, the Honorable Principal Judge,
and your lordships present, your worships, dear friends, let me adopt the protocol. I want to thank you, my Lord, the Chief Justice, for your kind invitation to me to come and give closing remarks at this conference. I also thank you for the wonderful event you hosted last night. Many of us managed to reach home after a sumptuous meal and partaking of various solvents. Some people were walking in italics, but that was the whole idea, that we should relax and be ourselves. We live in a world full of pretense. People are not real. And those are the things that undermine our wellness also. Nobody wants to appear vulnerable in certain settings, so they even stop being human. My remarks will be in two parts. The first is about the actual conference, and then I'll say something little which is for personal reflections. I'm pleased to join the closing session of this 27th Annual Judges Conference. I looked at the program, and even through the Executive Director of JTI, got a full briefing of some of the presentations at the conference. Your theme of judicial wellness has now dovetailed into how best the judiciary can achieve the theme's goal, and that is in alternative dispute resolution. Let me start by noting an obvious fact. Economies that grow in the world, be it the United States, United Kingdom, and even much of Europe, or even the so-called first world economies of the past 50 years, for instance, Singapore, actually do not settle the higher percentage of their disputes through courts. They do it through ADR. So it means there is a relationship between ADR and economic growth. Conversely, struggling economies, including our so-called third world countries, tend to adopt expensive, litigious adjudicative mechanisms. These are time-consuming and have a drag on the economies. My Lord Chief Justice, your own researchers have a lot of data on how much money is stuck in the court system because of our unwise option of going to court. The keynote address from the Honorable Chief Justice of Zambia called for Africanization of justice. This resonates with what judiciaries in Africa can and should do. Now, coming back to the theme of the conference, I'm happy about the recognition and the case made for judicial wellness. Africanization of justice is a theme and was indeed the essence of the speech that Her Excellency the Vice President read. In His Excellency the President's remarks, he talked about, in quotes, 3 interconnected concepts: Africanization of justice, the judiciary as an enabler of wealth creation, and the central theme of judicial wellness. These are not separate ideas, but different facets of the same goal: a justice system that is rooted in our context, responsive to our people, and conducive to our prosperity.
His Excellency the President further remarked that, and I quote, Africanization of justice means grounding our legal processes in the realities, values, and wisdom of African societies. It means recognizing that justice is not only delivered in courtrooms, but also through community reconciliation, restorative practices, and indigenous conflict resolution mechanisms. Judicial wellness can only be achieved if the judiciary, and indeed the entire justice system, adopts dispute resolution models that minimize stress. In opening the conference, His Excellency the President observed, and I quote, an overburdened, stressed, and fatigued judge cannot effectively Africanize justice or enable wealth creation. Agreeing with His Excellency the President, I therefore urge that judicial officers should adopt what I would call a judicial officer's ADR mindset, which means a shift from traditional litigation-focused adjudication to a philosophy of proactive conflict management. It involves viewing the courtroom not just as a place for final judgments, but rather as a gateway to more efficient, collaborative solutions. This mindset has 5 key characteristics. 1, problem-solving orientation. A judicial officer should prioritize underlying interests of parties over rigid legal positions to find mutually beneficial outcomes. 2, proactive facilitation. A judicial officer should actively identify cases suitable for mediation or arbitration early in the process to reduce backlog and costs. 3, empowerment of parties. A judicial officer should encourage litigants to maintain control over the resolution process, which often leads to higher compliance and restored relationships. 4, efficiency and proportionality. A judicial officer should balance the need for a full trial against the time and resources saved through alternative mechanisms. And 5, neutrality as a catalyst. A judicial officer should maintain impartiality while acting as a settlement advocate who guides parties toward self-determined closure. In his remarks, the President said, and I quote, wellness is a strategic tool. A well judge is a more present judge, able to listen deeply to community-based solutions. Concerning the place of ADR and AJS, His Excellency observed, and I quote, courts should not be the first stop for every dispute. Judges must actively manage cases and guide parties towards appropriate resolution mechanisms. I have noted from the conference program that the panels spoke to ADR in the segments of justice, from commercial justice, land justice, family justice to criminal justice. This tells me that the judiciary is taking ADR seriously, not only in the expeditious dispensation of justice in the courts, but it also speaks to the use of ADR now and in the future as a judicial wellness tool. The ADR discussion is not something that has just landed on this year's conference program. Last year, in May 2025, the judiciary led the organization of an international commercial arbitration training, and over the past 3 years, since 2022, the judiciary has led in key ADR initiatives. I'll mention 3. The first one, the judiciary has provided leadership in ADR in Africa in hosting the first Africa Chief Justices ADR conference. That was March 2023. 2, the Honorable Chief Justice Emeritus served as the first chairperson on the Africa Chief Justices Forum birthed out of that conference. And 3, the judiciary is hosting the secretariat of the Africa Chief Justices Forum. On the other hand, we at the Ministry of Justice, with your active support, led in developing the national ADR policy in 2023. The policy was approved by Cabinet in February 2025. We had the support of the judiciary and other stakeholders. The evidence is clear. The judiciary is providing leadership on ADR in a manner that is expected to benefit the whole continent of Africa. The Ministry of Justice will continue working with the judiciary through the Judicial Training Institute to deliver on sensitization and awareness on the national ADR policy. This awareness is critical because as lawyers, we are trained to fight. We are not trained to negotiate with anyone. That is our mode of operation. Secondly, my Lord the Chief Justice, there's also fear in the legal profession that this ADR is bad for business. As you know, many lawyers reap or fish in troubled waters. So if the waters are calm, there will be no fish coming to the surface. We must therefore enhance the awareness of lawyers that ADR is actually good for business. But this can only be done starting with training. I salute Kiriabwire J.A. for the seminal work he published. Finally, students at LDC are beginning to read about ADR, and I understand it is now also a course unit. Hopefully that will reorient lawyers to realize that if the pockets of clients are not overstressed, they may share actually a bigger proportion with you, the practicing advocate. There are other individuals like David Kagwa who need to be recognized for their efforts to set a standard. Basically, this will avoid us having Juakali ADR practitioners. I'm fully aware that the new court annex mediation rules drafted in 2025 are now with us at the Attorney General's chambers. I want to pledge that soon we shall submit them to you, my Lord the Chief Justice, so that you may sign it off and have it gazetted. The delay is explainable given the season we have been through, my Lord. I'm further aware that our Chief Justice, the Honorable Justice Flavian Zaija, has announced that one of the key ADR initiatives being mooted by the judiciary is the establishment of an Africa Dispute Resolution Center in Uganda. This is a very welcome initiative. Uganda must become a center of excellence in ADR. As Minister of Justice, I'm committed to work with and support you, my Lord the Chief Justice, on this initiative. I have at least 4 months at the Ministry of Justice. and that's enough time. Let me also draw attention to the fact that implementation of the national ADR policy is being reflected in key private sector initiatives. I regret that we were not able to bring printed copies of the national ADR policy due to logistical problems, but we promise to deliver copies to you, my Lord the Chief Justice, for distribution. After all, we co-own this policy with the judiciary. One such private sector initiative is the Gumzola ADR conference. It is a Swahili phraseology, which is scheduled to take place in Kampala on March 9th to 13th this year. This conference, which is called Gumzo la ADR, is being convened by the ALP, or Africa Law Practice Dispute Settlement Hub, a private sector ADR provider. Our ministry is collaborating with them. The event is planned to bring the judiciary, government, private sector, and ADR professionals in the same space to talk about mediation, arbitration, AJS, and construction adjudication. My Lord, I'm also an accredited court mediator, and once in a while I faithfully show up at the commercial court, leaving my title of minister outside the gate, and serve your court as a mediator. I have managed to settle very many thorny disputes, and none of the parties have found any problem with me so far. There are many others like me in that space. I wish to express immense gratitude to the judiciary for bringing us where we are on ADR. My Lord Chief Justice Emeritus, you have truly put your shoulder to the wheel of ADR, and you have not allowed it to slip back even 1 inch. Indeed, you have been so militant to the extent of turning our phrases upside down by saying it is the system you presided over for many years which should be the alternative dispute resolution system, that the ADR is actually the real African dispute resolution mechanism. During our time, and in my time as Minister of Justice, the national ADR policy is now out. On the part of the judiciary, the alternative justice system strategy is also out. Now, these are the pivotal frameworks for ADR in Uganda today. And I think in this conference, these milestones should be celebrated. To that end, I want to thank you, my Lord Chief Justice Emeritus, and Deputy Chief Justice Emeritus, Richard Butera, and the then Principal Judge, who is now the Honorable the Chief Justice, for their unwavering commitment in the development of the AJS strategy and the national ADR policy. When I first saw the word wellness, I thought this was actually just about health, and my mind was running to a number of things. But I still think it is important that we have judges who are doing well health-wise. There's a story I read about a reunion of friends. Once in a while, people want to meet, maybe after 30 days of chasing their dream, 30 years, of chasing their dreams. And when people meet, everybody wants to look their best. So in this story, there's a lady who entered the banquet hall very well dressed, and everybody in the room was acting as if everything in their lives had gone perfectly well. So they were busy telling each other lies. So how is life? Life is wonderful. How is family? Family is okay. But one lady just stormed out of the hall and went to the hallway, the corridor. And then a friend noticed and followed her. And then he asked, "Why have you stormed out?" And the lady said, "I'm tired of pretending. My law firm has collapsed. I've filed for bankruptcy. I'm divorced. And I'm here pretending that everything is going as I planned 30 years ago." Then the gentleman who followed us said, "Even me, it is the same. I'm now a paralegal. I used to be a top lawyer. I'm now doing paralegal work. And soon many people came to the corridor, each of them confessing that things had actually not worked the way they had planned. Others came and said, I'm struggling with drug addiction. My husband is struggling with alcoholism, and so on and so forth. Now, that is really part of wellness. So, as we sit in this room, you have to ask yourself, who in this room would you trust with your secrets, the one you don't share when you appear for a reception? Now, this story was shared to me by a friend of mine who we have been friends since we were 12. I don't know how many such friends you have, we who are here in this room, because those are really the true friends. The colleagues on the bench may not really be your true friends. They are colleagues. You talk about precedent and laws, but would you do what, for instance, our former vice president did? I'm talking about Her Excellency Specioza Kazibwe, whose husband used to beat her up, and nobody knew. Until one day she decided to state it publicly and said, you know, I go to the UN, I get a standing ovation, the first African vice president, but when I go home, I'm battered by the love of my life. I think that is really part of wellness. We need to have a circle of friends with whom we talk about these sensitive issues. In our class of 1988, fortunately, we are very free with each other. And there are very many of my classmates here. And many times we actually talk about these very deep and personal things. Because when you share these things with others, it contributes to your wellness. Because we live in a world of social media. Recently, I posted something on social media about a lady who had gone to a TV show and said, you know, me, I can't date a man who does not have a Mercedes-Benz or a Land Cruiser and so on. Later, she was photographed on a border going home. In short, wellness is about being a person, not a personality. Because here, we all want to be a personality. And there are those of us who, for instance, dropped out of the institution of marriage, then enrolled again after very many years, and went to the altar again to repeat the vows. I think I've concluded, and this is not an original quote, that perfect people are not real, and real people are not perfect. And I think when we talk about our imperfections, then we become healthier in the mind. Because here, you are your lordships, you are in the gown, but the person inside the gown is going through a lot of things. And now, who are you going to talk to? The GM Bijirimana put there cannot deal with those issues. Neither can the massage parlor, because that massage parlor has a total stranger who is paid to tone your muscles and so on, but cannot understand what is going on in your head. So, these people, eventually almost half of the guests at that reunion went to the corridor. So they decided to form what they call the hallway truth tellers. I think telling the truth to each other is very important. And part of the stress is when you try to benchmark other people. When I was growing up, first I failed the interview to be a state attorney. That really stressed me. Me, Norbert Mao, not being hired to the lowest level in the Ministry of Justice. But my uncle, Justice Ralph Chan, counseled me and he told me that, you know, The panel didn't think that you were a very good material for the public service, given your antecedents at Makerere. So it has nothing to do with your legal skills and so on. Now, secondly, my classmates know that I was really a struggling student, not because I'm dumb, but because my priorities were elsewhere. There are many people in this room from whom I borrowed notes and had to go to Wandegea to photocopy. It is even a miracle that I passed without having to sit any other paper. So, I want to put it to you, my Lord, the Chief Justice, and your Lordships and the worships here, that wellness is about removing our masks. I think we all move around with masks. So after failing that interview, I refused to go back to Jinja. In Jinja, we lived in a nice home on Wilson Avenue, and that's when I first saw Her Lordship Justice Lillian Ekirikubinza. To me, she has always been Auntie Lillian because the young men I grew up with, she was their aunt, so she also became my aunt. And I keep telling her that she should warn herself when I one day appear before court and I say, Auntie Lillian, to her great embarrassment. But I was now in Kampala, jobless. Eventually, Kabugo and Company took me in for a salary of 50,000 shillings. So I would hang my suit in the office and then wear tracksuits and walk from that office on Entebbe Road up to Nakulabye via Makerere Chivulu. And it helped me to also listen to the stories of real people. As you walk with the struggling masses of Kampala, they tell you their plans. One day I overheard a young man saying, tomorrow, he was a sugarcane dealer. He used to push sugarcane in a wheelbarrow. So he said, tomorrow I must come early before the space in the fridge is taken so that my sugarcane can be cold and I can get better clients. Of course, they didn't know that I was LLB, Deep LP, advocate. I was just one of them. I was there in my canvas shoes. And but I was also going to Nakulabye to sleep in my room, which was otherwise meant to be a store, actually. I had requested a friend of mine to give me a room because I told my parents, I'm not coming back after Makerere. I'm now a man. But life was hard. So before reaching home, I would buy this fish, the Nile perch known as sabulenya, and go back home and buy tomatoes and fry it again, make posho, and that is a meal. And LLB, Deep LP, former girl president, future president of Uganda. So what helped me? What helped me is that I had friends to whom I could talk. One day there was an essay writing competition. I saw it in the newspapers. So I borrowed a typewriter and I wrote an essay. And my essay was one of the winning essays. The American ambassador invited me to the embassy on Parliament Avenue then, shook my hands, gave me $150, and then eventually gave me an air ticket to go to America for 6 weeks. And that is how I started changing my life slowly. I now decided that I must now become a political leader. So I went for election and I lost. So I came back to Uganda Law Society where Justice Solomon Balungi Bossa was the boss. I got the job, I think, because I was the only applicant. Because the job was in Gulu. Nobody wanted to go to Gulu in 1994. It was very tough. There was a war going on. So the interview, as I've said before, was basically a counseling session. I wasn't asked any relevant question. She was simply telling me not to be afraid of serving the Law Society, that she would support me. So back to that wellness. We must stop comparing our internal realities to everyone else highlight reels. We must find our hallways, find the people who will sit on the floor with us, and we tell them the truth. And if need be, we can even cry together. Because for some of us, all my friends were organizing wedding meetings. Me, I didn't even have a date. Or rather, I hadn't made any commitment. So, I attended so many wedding meetings. So, this article concluded, and I quote, "Success is not about having a perfect life. It's about surviving a difficult one and having the courage to admit it. We have all peaked, we have all crashed, and we are all just trying to make it to the next chapter. And that is more than enough." And that's why I love that photo of the Chief Justice Emeritus laying bricks in the village for a church. I think wellness is about being real to the person in the mirror, because that is you. And as we age, particularly, this is important. Sometimes I stand before a full-size mirror and I don't like what I see. Instead of the 6-pack, now I have 1-pack. So I must learn to be okay with the 1-pack. So that is my little story about wellness. Finally, this surviving among very brilliant people. That is how this Tom Sawyer thing comes. So when I arrived at the Ministry of Justice, His Lordship, the Chief Justice Emeritus, called me and said, "There is a course, a master's in dispute resolution. I think you should enroll. We already started, but I know you are bright, you can catch up." Generally, such encouraging words, inciting me to fall in the trap. So I foolishly said yes. Then it required me to attend 3 Zoom meetings every week. There were assignments, discussion groups, and the classmates are people who are full-time dealing with the law. And me, I'm full-time with the villagers, insulting my opponents and so on. 2 different worlds. So I became the misfit in the class. And I think some people made a bet. I think Francis Gimara, senior counsel, made a bet with my wife. My wife insisted that I was going to drop out. And Francis Gimara challenged her. "Make sure you always remind him of the classes and so on. And if he graduates, I'll give you a present." I don't know what they agreed on. So as we headed towards graduation and I had caught up and I was now sounding like a proper member of the class, and people wondered how I was managing. Of course, I depended a lot on the wisdom of my discussion mates and so on, and listening in, getting notes I have missed, because the ministry is a busy place. And in the ministry, you have a real boss, namely the president of Uganda. In the judiciary, you have an administrative boss, but in your judicial function, you really don't have a boss because your allegiance is to the judicial oath. But in my case, if the president says, "Off you go to Addis Ababa, go and deliver this letter to the Prime Minister of Ethiopia," you have no choice, you have to go. So that is how I told them the story on Mark Twain's Tom Sawyer. Tom Sawyer was a person who was quite a funny character. So he pretended that he had mastered the Bible, yet he hadn't. So one day, a judge came to the class and asked the class teacher, are all the kids now okay with the Bible? Do they understand their scriptures? And the teacher said, for sure. But the teacher secretly knew that there was this student, Tom Sawyer, who was not quite up to the mark. So the teacher said, can I ask any question? And any of the students can answer? The teacher said, for sure. So the teacher asked, who were the first two apostles that Jesus called? All the students put up their hands, including the famous Tom Sawyer, who knew very little about the Bible. So the judge decides to pick Tom Sawyer. And the book says the teacher's heart sank. Said, this is a bad day. So the judge then says, Tom Sawyer, tell us who were the first two apostles Jesus called. And Tom's head was blank. He thought and thought nothing. They urged him. Finally, he blurted out, David and Goliath. My Lord Chief Justice, I hope I was not that bad. I know you call me TS for Tom Sawyer. But the fact that I graduated means I somehow managed to wing my way. To wing my way through. And of course, Tom Sawyer had other exploits. One day he was given a punishment to paint a wall. And then he was found painting the wall. All the other kids came around and said, Tom, what is this? He didn't tell them what was a punishment. He said, you see, unlike you, I'm now doing things for adults. You kids go and play. For me, I'm painting this wall. So all the kids now say, Tom, please allow me paint this section. I also want to be an adult. So the kids lined up and Tom now sat down under a tree relaxing while the kids were fighting to paint it. So, my Lord Chief Justice, I hope that's not me. So, what is the way forward? And this is my concluding passage. His Excellency the President gave us the clarion call, which I wish to repeat. He said, and I quote, use this conference to build a roadmap where Africanized justice, wealth creation, and judicial wellness are integrated into your strategic planning, performance indicators, and daily operations. His Excellency has urged us to build a judiciary that is truly of Africa, for Africa. I now take this opportunity and honor to close the 27th Annual Judges Conference. God bless you all. God bless Uganda.
Another round of applause for the Honorable the Minister. Honorable Minister, thank you very much for your address, for sharing your personal journey and stories with us and insights. Delivered with a little bit of humor or a lot of it, the points are well taken and appreciated. But most importantly, Honorable Minister, we thank you for officially closing this conference. And another round of applause for him for closing this conference. Honorable Minister, we were joined by the Honorable Deputy Chief Justice Emeritus, Honorable Richard Butera, who is here with us. My Lord, thank you. Honorable Minister had also earlier indicated that we had the Honorable, the Principal Judge with us, Lady Justice Jane Frances Abodo. She had moved out, she's here with us. My Lord, thank you. As we come to a close, I want to thank all of you for coming, my Lords and your worships. We thank you for the active participation and contributions that you made at this conference. We wish you a safe journey back to your homes as we wait to receive you tomorrow at the headquarters for the opening of the new law year. We welcome you for that ceremony tomorrow, and we shall be there to receive you. And now may we rise for the anthems. Thank you. I request that you briefly take your seats. This brings us to the end of this conference, and we shall go into a photo session, which we shall have at the steps of the entrance to the convention center, and His Worship Pereme will come and guide us. But thereafter, we shall go for lunch, which the Honorable, the Chief Justice has been gracious enough to give us as we depart to our homes. I thank you.
Our guest of honor, my Lord Chief Justice, I request that we proceed if we have the photos. We shall have basically two photos. Our guest of honor, Chief Justice, and all the judges and the justices. And then the second will be with the registrars. I take this honor to pray for the food that we shall have immediately after the photos. Lord our Father, we thank you for this far how we have come. We thank you for all the people that you have kept here the last 3 days. And as we go to take the meal that we are going to have, bless it so that we can partake of it and go back and serve humanity. In Jesus' name, I pray. Amen. So protocol members, please let us lead our guests so that we can have those two photographs, and my lords thereafter proceed to have your lunch. In any event that you have not yet signed on the photo frame for our Chief Justice Emeritus, it is still available. Please take off time and you append your signature on that wonderful piece of art. Anyone who might have not yet moved their luggage or checked out from the hotel, please do that as fast as possible so that you are not inconvenienced by the hotel. So thank you so much.